Where's the camera, by the way? Where do I, oh, there. Okay. Good morning. Let's get started. Today is Wednesday, December 28th, 2022. The time is 9:33, and this is our regular weekly meeting of the New Mexico Public Regulation Commission. I'm Chair Cynthia Hall, and we will call this meeting to order. Mike Smith, can you please call the roll call, please?
Sure. I'm a present. Commissioner Maestas.
I'm here.
Starting with Commissioner Cynthia Aguilar.
Mike, you're not on the speaker. I'm here. This is Commissioner Cynthia Aguilar.
Sorry, my microphone was off. Commissioner Fishman, do we have you? I do not hear from Commissioner Fishman. So moving to Commissioner Cynthia Hall.
Present.
We have 4 commissioners present. That constitutes a quorum for doing business under the NMPRC Act.
Okay, thank you very much. Next, we'll have the Pledge of Allegiance and the State Pledge. And I guess I'd like to ask Wayne Probst, our outgoing Chief of Staff, to lead us. It'll be our last opportunity to hear to do this.
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Wayne. You'll be missed. Next, we'll have consideration and approval of the agenda. Commissioners, do you have any changes you want to make to the agenda? Hearing none.
Madam Chair.
I think
Yes,
Hans is probably about to say what I was going to say, but I'll let him say it.
okay.
Thanks, Mike. I need to remove consideration and approval of the minutes of December 7th open meeting. I have not received those from Mr. Boaz, so I'll have to bring it back under the new commission.
Okay, thanks very much, Hans. Do we have any other changes? Commissioners, now's your chance. All right.
Madam Chair,
Yes.
move to approve the agenda as amended.
All right, thank you very much. I've got a
Second.
motion and a second. So Mike, can you please take the roll call on that?
Commissioner Byrd. Aye. Commissioner Cynthia Aguilar.
Aye.
Commissioner Hall.
Aye.
Commissioner Maestas.
Aye.
And just checking, Commissioner Fishman, are you present? Does not appear so. We have the agenda is approved by a vote of 4-0.
Thanks, Mike. Okay, now we'll move on to introduction of special guests. Do we have any special guests here today? I'm not seeing anybody. Anybody aware of any? Hans?
I am not aware of any special guest requests today, Madam
All
Chair.
right, thank you very much. And now we'll move on to public comment. Hans, do we have anyone sign up for public comment?
Yes, we do. Ms. Brooke Trammell wishes to address the commission, and I do see that she is logged in.
Okay, and I noticed that Mark Fenton also raised his hand. So I thought, did you raise your hand, Mark Fenton? I thought you did. Okay, so we'll take Ms. Trammell first.
Good morning, Madam Chair, Commissioners.
Good morning.
Please excuse my voice. It's a little off today, coming off of a cold, but my name is Brooke Trammell. I am Regional Vice President, Regulatory and Pricing for SPS. I just wanted to...
I'm sorry, just a minute. Could whoever's running the screen, can you put that on speaker view so we can see you better? So the public can see you better.
Thank you. Again, Madam Chair and Commissioners, I just wanted to take a couple of moments this morning to address the Commission Thank you for the opportunity to make public comment today. I was unable to attend the commissioner's reception. That was earlier this year, I think in November, but wanted to just take a moment and thank you all for your service to New Mexico and your service to the commission while on this bench. I also wanted to thank the commission staff for managing through times of the pandemic and the challenges and opportunities that presented all of us over the last couple of years. But wanted to thank Mr. Probst for his leadership at the commission and to wish him the best in his next endeavor. And I think we all can understand there's a lot of seasons in life. Seasons change and change is pretty constant, but I wish everyone the best. And I just hope that you all have a very wonderful new year. And again, thank you for everything you've done for New Mexico and for utilities and our consumers and customers and communities. Have a great new year and take care.
Thank you very much, Ms. Trammell. It's really a pleasure to have been able to work with good companies like yours. And I'm sure with leadership like yours going forward, New Mexico will be well served. Thank you very much for your comments.
Thank you.
I'd like the record to reflect that Commissioner Fishman has appeared in our meeting. Let's see, and I'd like to, then let's hear from Mark Fenton from PNM.
Hi, I'm Mark Fenton, the Executive Director of Regulatory Policy and Case Management at PNM, as you all know. And I also wanted to make some remarks to this commission. You know, I've been working at PNM for quite some time, and the last several years, one of my roles is to work with the commissioners. And I just want to say on a personal level that I appreciate all 5 of you commissioners and the way you've treated me and with the respect and professionalism that you've treated me. I'm always involved in outages and communicating with you on a variety of subjects and getting on open meeting agendas and other things. And I can't say enough about how professional you've been to me. And I really appreciate that. And I just want to thank you for that. Thank you for the way you've treated me as a professional. I wish you all the best from the bottom of my heart. I would also like to make a comment about Mr. Probst. I've also worked with a lot of chief of staffs over my career at PNM, and Mr. Probst is probably the strongest chief of staff that I have worked with. I mean, I'm saying that with all sincerity and honesty, and I know he's going to be missed, and that was a great hire, and I wish him the best of luck as well. So good luck to all of you. Thank you.
Thank you very much, Mark. We'll miss you. All right. So, and we have nothing in the consideration and approval of prior minutes items. So we'll go on to what would have been a presentation by Tamara Shayton. He's a economist that we weren't able to hire due to his need to stay where he was, and probably our salary offer as well. I don't know, but he was at least able to work for us on a contract basis. And I had noticed on his resume that he had done some research and productivity arising from mergers. And I had asked him to prepare some sort of analysis, an objective analysis about productivity versus antitrust issues or whatever might have been the con in the Avangrid PNM merger case, simply because I know that there's a possibility of that case returning to the commission. And I thought while we had attempted to create advisory positions for the commission, we weren't fully successful in finding people that we could hire. I thought we could at least get some sort of advisory objective analysis of our own. And so that's what Mr. Shayton provided. And unfortunately, he's on a family vacation now, and he's at a location where he had some uncertainty whether there would be an internet connection. However, in fact, where he is in Northern California, I guess the power is out in that town. So there's no way that he's going to be able to make this presentation today. So I'll just mention that this analysis was created for us, and it may be of some use to the next commission in the event the Avangrid case comes back to the commission. But in any case, it's something that was designed to provide just a theoretical grasp for the commission to understand the arguments better that were made in that case. So it'll be posted on the website like our other research from another advisor we did have on staff for a while. And it'll be available for the public to see and for commissioners to use in the future. So without spending time discussing the contents of that, I think we'll move on to the next item, which is the consent
Madam
action
Chair?
items. Yes,
Madam Chair.
is it Commissioner Vicente Aguilar?
Thank you, Madam Chair. If I may, I know that Mark Fitton made a comment a few minutes ago. Can I also make a comment in reference to his capacity working on behalf of P&M?
Yeah, yes. Now, I didn't quite hear. I'd like to ask the IT folks to raise the volume in here like they did a couple of weeks ago. So I can at least hear better. Could you repeat the first part of your statement, Commissioner Vicente Aguilar? I didn't catch it all. I know you want to speak about someone, but I'm not sure who.
Oh, yes, Madam Chair, I wanted to thank Mark Fitton.
Oh, yes, please do.
Mark, greetings from the Navajo Nation. We're in the middle of a heavy snowstorm. It's good. We need the moisture here in New Mexico. But as far as Mark Fitton is concerned, I don't know if you are aware, but when we work with you, you did your job according to how to work with every commissioner individually.
Commissioner Vicente Aguilar, excuse me, can you maybe get a little closer to your microphone? We're having trouble hearing you here, I think.
Okay, I will. I will.
better.
Can you hear me now?
Yes.
What'd she say?
Can you hear me now?
Can you hear me now?
No. Let's see. Christopher Hall, could you please go ask someone in IT to raise the volume in here? I know they can do it. They've done it before. Okay, Commissioner Vicente Aguilar, can you please say something now? Commissioner
Can you hear me
Vicente,
now?
yes, that's much better.
Okay. I just wanted to thank Mark Fitton for his work. As I was saying, he worked with, I think, all the commissioners individually on a professional basis. And he did not create any type of an overreach over the years. He respected the commissioners. If he wanted to do something about one district, about one commissioner, he asked. He made a phone call. He sent a text message. That is so very much professional. And I didn't get that from the other P&M employees. In fact, they wanted to, contact me a certain way. And, because of the ex parte, I distanced myself, but Mark Fenton was different. He knew the lines were, he knew where the boundaries were. So I just wanted to thank him that he did his job so professionally. Thank you, Madam Chair.
Thank you, Commissioner Vicente Aguilar. I completely agree with you. Mark was always extremely professional to deal with. It was very well appreciated. Okay, so I think we're at consent action items. There are none on this agenda. Now we get to an item called administrative action. We don't always have on the agenda, but we have several resolutions we have to adopt. So the first item is Michael Smith with an order designating General Counsel Michael C. Smith, interim chief of staff and delegated authority pursuant to Rural dash, I guess, 1.2.10.9 New Mexico Administrative Code. So Mike, take it away.
Commissioners, so this is actually just a formality normally that we do with respect. Oh, it's pointed the wrong way. This is a formality that we do with respect to changes in the chief of staff position and when new commissioners come on and not because the state rules act requires that the head of agency or a designee be identified to the state records department for transmittal of records such as rulemakings for publication in the state register. And so we usually have this on the first as one of the first items of the agenda at the beginning of each year. However, or when there's a change in personnel. So in this case, this is also a formality that I wanted to put in place because unlike normally where the commission designates an interim chief of staff pending the appointment of a permanent chief of staff, there's a commission in place. And we're in a position right now where there's potentially not a commission in place. And so I wanted to make sure that this was reduced to writing. So this accomplishes both purposes, that if there's a need to demonstrate that the commission took this step and there is a need with respect to the records department, this is what that this order tries to do or seeks to accomplish, let's put it that way. So I put this in the form of a resolution. And I will read what it states. It says, whereas the terms of office for the current elected commissioners of the New Mexico Public Regulation Commission will terminate effective January 1, 2023, in accordance with Article 11, Section 1A of the New Mexico Constitution. And whereas Wayne Probst, the current chief of staff, has resigned his position with the New Mexico Public Regulation Commission effective January 1, 2023. And whereas there is a need for a formal written appointment of an interim chief of staff to perform the duties of that position pending the seating of an appointed commission pursuant to Article 11, Section 1B of the New Mexico Constitution, including as the commission's designee to act on behalf of the commission with respect to the transmittal of rule filings to the New Mexico State Records and Archives under Rule 124.10.9 and Rule 124.10.10 NMAC. Therefore, be it resolved that Michael C. Smith is formally appointed, as interim chief of staff effective January 1, 2023, and authorized to perform all duties of that position, including acting as the commission's designee to act on behalf of the commission with respect to the transmittal of rule and records filings to the New Mexico State Records and Archives under Rule 124.10.9 and Rule 124.10.10 NMAC. This appointment and delegation of authority shall remain in effect until such time as action is taken to revoke such authority by an appointed commission seated in accordance with Article 11, Section 1B of the New Mexico Constitution.
All right, thanks, Mike. I think that's all we need to hear from you on this, right? We'll sign it
Correct.
at the end of the meeting. Or how do you want us to
We do
proceed?
need to approve.
There needs to be a.
Oh, yes.
Madam
Okay.
Chair,
Yes,
I'll move to approve resolution 1228-2022-B.
okay,
And let me mention the title, a resolution designating interim chief of staff and delegating authority with respect to state records and archives filings pursuant to R1 2410-9 and R1 2410-9 NMAC.
That's a typo, actually. I'm sorry. It
I
should
guess
say 10.
it's the same thing,
Yes. The second one should be 124-10-10.
1010.
Oh.
Oh, all right.
okay, I've got a motion. Do I have a second?
I will second.
Okay, got a motion and a second. Mike, can you please take the roll?
Commissioner Vicente Aguilar,
Aye.
Commissioner Fishman,
Aye.
Commissioner Maestas,
Aye.
Commissioner Hall,
Aye.
and Commissioner Bird.
All right.
Resolution is approved by a vote of 5-0.
Thank you, Mike.
Condolences, Mike.
Thank you.
Okay, so next we have an item presented by Hans Muller. And this is an order delegating authority to authorize approval of issuance of temporary authority regarding applications for reissuance of certificates. Hans, would you like to proceed?
Yes, thank you, Madam Chair. Good morning, Commissioners.
Morning.
What I present for you today is Resolution 1228-22A, which is a resolution delegating authority to the Transportation Division Director for temporary authority approval regarding reissuance of certificates. And similar to what Mr. Smith has indicated, my concern here with a potential lapse in time of a sitting commission is if we had an application for reissuance of certificates come in during that lapse. And in the interest of making sure that those certificates, especially for ambulance carriers, do not expire due to lack of a sitting commission, I feel the delegation of authority here is proper to the Transportation Division Director so that any reissuance has temporary authority approval until a sitting commission can formally approve the reissuance of the certificate. So the resolution, very similar to Mr. Smith's, would say, whereas the terms of office of the current elected commissioners of the New Mexico Public Regulation Commission will terminate effective January 1st, 2023, in accordance with Article 11, Section 1A of the New Mexico Constitution. And whereas the commission is responsible for approving the applications and authority of certificates for transportation carriers, including ambulance services in the state of New Mexico. And whereas there is a need for a formal written delegation of authority to ensure that public safety is not encumbered and that operational authority of existing motor carriers continues for those motor carriers applying for reissuance of their certificates pending the seating of an appointed commission pursuant to Article 11, Section 1B of the New Mexico Constitution. Therefore, be it resolved that Jesse C. Montoya, Transportation Division Director of the Commission, is hereby delegated the authority to approve temporary authority for any applicant who has submitted an application for reissuance of their certificate subject to the terms and limitations listed below. The delegation of authority shall remain in effect until such time as action is taken to revoke such authority by appointed commissions seated in accordance with Article 11, Section 1B of the Constitution. And I have checked with Transportation Division staff. They have informed me that to their records, the next certificate for an ambulance service that is set to expire is February 5th. So hopefully we do have a seated commission before that, but in the interim, this resolution would at least grant temporary authority to any incoming applications, so there is not a lapse in coverage of those certificates. And with that, I'll stand for any questions.
Thank you very much, Hans. Commissioners, any questions for Hans about this? Hearing none, I'd like to entertain a motion for approval.
I will move to approve the order delegating authority to
Thank-
authorize approval of issuance of temporary authority regarding applications for reissuance of certificates. Is that 124-1010 NMAC? Was that what Mike was saying?
Let's see.
No, that would not be.
No,
Oh, okay,
no.
that's okay.
All right, well, we have the motion. So folks, can I get a second?
Second.
All right, I got a motion and a second to approve this resolution. Mike, can you take the roll?
Commissioner Byrd,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Fishman,
Aye.
Commissioner Hall,
Aye.
Commissioner Maestas.
Aye.
Resolution is approved by a vote of 5-0.
Thank you very much, Mike. Okay, now we'll move on to regular action items. Under transportation matters, we have none. And under utility matters, we have 3. And the first is case number 22-00222-UT in the matter of the Commission's 2022 review of impacts of the New Mexico Telecommunications Act and report to the legislature pursuant to NMSA 1978, section 63-9A-21. Russell Fisk will be presenting a potential order adopting a report to the legislature. Please, Russell, are you there? Russell Fisk, are you on the line or in the Zoom? I don't see Russell anywhere.
I'm not seeing him currently on the list of participants, Madam Chair.
You're gonna do,
Let me reach out to him.
okay. I would suggest we move on to the next case, but they're all Russells. Do we have Mike on the line? Is Mike there?
He's on. Is he?
Um,
Yeah, he is.
Mike Rippiger, are you on the Zoom meeting?
He's there. There he is.
Madam Chair, Commissioners, yes, I am. I don't know, if it's appropriate for me to speak for Russell for this issue, but I can tell you that staff has been in contact, or we have spoken with Russell about the report. His intention was to have the report prepared and ready for filing by the end of the week. There's a couple odds and ends in the report he would like staff to adjust. I believe that he is of the mind that he would file it in pretty much the shape that it is in now. There's a few data points having to do with consumer complaints that we need to get together in coordination with the Consumer Relations Division, but this report will be ready. It is close to being ready now, but it will be ready to go with the coordination between staff, CRD, and Russell, hopefully very soon, by the end of the week. If not, it would be soon after that.
Thanks, Mike. I had some concerns about the report to the extent that that CenturyLink, unlike the last time they filed a report, or last time that we prepared a report, the information that CenturyLink has filed with the commission has been filed with as confidential information, with the result that most of the items that the legislature wanted to learn about are not available in the report, and the report doesn't contain any kind of analysis of that information. So, and the report, in case you're not aware, there is a page, there are several pages where that are entitled the second report of the New Mexico PRC to the New Mexico legislature concerning impacts of the oh, wait a minute, that's the second report. Well, there's an update document basically that discusses the fact that all this information is had been submitted to the commission as confidential, and any changes to be made to our first report are simply placeholders, but they don't contain any current information from 2017 on. And what is proposed by Mr. Fisk is that if the legislature or a legislator requests information, then the PRC can develop a protocol whereby they could provide confidential information that's requested. My problem with that is that doesn't make it easy for the legislature at all. And they passed a law saying that they want this information. So I think that the least our agency can do is develop a protocol to provide for viewing of the confidential information. And I frankly think our agency should develop the analyses that were done, similar to the ones that were done in our first report of that confidential information, and make those analyses available in a confidential manner to members of the legislature. And in fact, I did write an email back to Russell on this subject, and I described a procedure that was used by the insurance division and then the Office of Superintendent of Insurance when they broke away from the PRC that I was aware of from having worked there. And they had a method by which outside companies could come in and view confidential information of their competitors if they signed a non-disclosure agreement. And so I suggested that methodology, and I would suggest to our commission that that our agency develop that methodology right away, because otherwise I don't feel that we've really complied with the spirit of the law in any way. So far this time around, our report is 6 months late. We should have had it ready in July. And we don't even have a methodology described whereby this confidential information is available. And I think all the commissioners on this bench know how challenging it is for legislators to get information in a timely way, normally under the circumstances of their job. So I think we should at least have a process in place that they can employ that's convenient for them. And it may be that it can all be done online, but my understanding is no one's consulted IT about that yet. Maybe they have, and I just don't know. But without Russell here to tell us about that, I'm sorry, I have to talk to you about it, Mike, but.
Well, Madam Chair, this is
Oh,
Russell. I'm sorry for my lateness. I think I hear what you're saying, and I would presume that the legislature does have some sort of procedure. I don't know what it is. I've never transmitted information under a claim of confidentiality to the legislature. So I don't know how they would go about that. I don't know if agencies have done this before. I assume that's happened before, that an agency has submitted confidential information to the legislature. And I think you're right. I think it would involve the recipients would be signing some kind of non-disclosure agreement, just as we do, the commission's own standard protective order, provides a form confidentiality agreement for anyone. If you're, for instance, in an adjudication, the parties to the case, their attorneys and their staff of their attorneys can access the confidential information by signing such an agreement. I think this involves something like that. What I'm guessing is that the legislature has some kind of procedure, and if not, then a standard procedure, I would guess. I don't know that, but I think we kind of have to wait and see. So I don't know what we could develop at this point. We need the cooperation of the legislature, someone there to do that. So I mean, I thought this is just setting it up so that they can do that. And maybe I shouldn't even say should. I think maybe what's the revision that's really needed for my for the report is not to say should the legislature or any legislator wish to see the confidential information, then we will facilitate that. Because obviously,
Russell,
I think yes.
Russell, excuse me.
Yes.
From what you just said, I think I completely disagree with. I don't want to wait for the legislature to ask. We're supposed to prepare a report. We're 6 months behind on that. But we do have the information. We need to put it we need to at least develop a protocol, or at least, as you say, communicate with the legislature, but they don't know this problem unless we tell them about it. So to me, it's a little nonsensical to wait for them to ask. I think what we should do, what I would like to see General Counsel's office do, is reach out to whoever you can figure out is the right person at the legislature and their administrative services to determine if they have some sort of methodology you're talking about. If they don't, then I know very well that our agency can do it because we did it in the past. So I think that's what I'd like to ask you to do forthwith this week. We've got 2 more days, and the legislatures turns into a real frenzy once they get started, and we are falling down on the job if we don't make this stuff available. It's a barrier enough that everything's been filed confidentiality for reasons are opaque to us, and we need to do as much as we can to make it available. So in any case, I'd appreciate if you could proceed that way, reach out to the commission, to the legislature. And that's my opinion, commissioners, fellow commissioners. If you have other ideas about this and would like to share them, I'd appreciate hearing it, but that's what I would like to see us do. Commissioners, do you guys have any comments about this or any Any questions to Russell about the contents of the report? Commissioner Vicente Aguilar, I can see these two shaking their heads up here, and I don't hear anything from Commissioner Fishman, but do you have any comments?
Yeah, thank you, Madam Chair. As you all know, Russell has been working very hard on a variety of cases, El Paso electric cases, you know, and the water issues. And we all know that the General Counsel, their office is overwhelmed with work that needs to get done. And I realized, yes, I agree with you, Madam Chair, that this is, you know, approximately 6 months behind. But yeah, I would do whatever Russell can do the next couple of days to update the record and to, you know, provide transparency. That's very important. And I know it's a challenge for the commission when industries ask for protection of an order, of a certain order. But I think this is well in line with your concern, Madam Chair. So I agree with you. Thank you.
Thank you very much, Commissioner Vicente Aguilar.
Madam Chair?
Yes, Commissioner Fishman.
Yeah, as a general proposition, CenturyLink has been fairly resistant to forwarding information and reporting, and at least since I've been on the commission, always interpreted everything in a manner to minimize the information that they put forward. And you know, for Mike and for Russell, I know that's just been a real challenge to deal with. I do think it probably makes sense to check in at a minimum with legislative counsel and see if there's a way that you can have a this is the wrong term, non-redacted report, but a report that has the information available with legislative counsel that legislators can just ask for without having to go through any big rigmarole. And so I'm just throwing out the suggestion that might be something, Russell and Mike, that you want to look into.
Thank you, Commissioner Fishman. That's a fine suggestion. And I would just echo your comments about how CenturyLink does seem to resist providing information. I spent some time last night going over all this because I was so shocked. But the statute is very clear about items of information that they want, including the impact on rates, on service quality, on employment by incumbent local exchange carriers, by the availability and deployment of high-speed data services, and whether or not wire centers serving areas that have been deemed to have effective competition information on those wire services, if they have been deemed to have effective competition, and on wire centers that are no longer subject to a carrier of last resort obligations. Those last two items apparently were not even described at all in the information we received for our first report, and we received no other information on those.
Oh, Madam Chair, that's actually not the case. If you see in the conclusion, what I've said there, or would have the commission say there, is that those two issues are not addressed because there's no update on that, on either of them since the initial report. I mean, there was no actual change. There's been no change. No, maybe we need to clarify that. No,
well, I meant to ask you about that, Russell, because you said there is no update. here, but you said there was no change in the report, and I wanted to inquire, is that because we got no information? Are we inferring?
I see what you mean. No, no, we would know because those effective competition requires findings by the commission, and there was an effective competition petition filed by CenturyLink, but that was filed. It was decided, and it was appealed, and we won in time for the initial report. All that information is in the initial report, and there's nothing filed since. So there's no news.
So we're inferring there are no changes because we don't have one word written on paper about it, right?
Well, we absolutely would know. We would have to. The commission has to approve that the designation of a
All right.
wire center or as subject to effective competition. So there's no way the commission has to be involved in that process. So there isn't any news there, but I can clarify that.
Well, and excuse me, I just
I did say there has been no change in either of these areas since the commission transmitted its initial
I
report.
appreciate that. I would like to finish my statement. And that is that these other items related to rates and service quality and employment were all filed as confidential information, which is to protect an entity from its competitors getting a competitive advantage with the use of that information. And I just wonder at the whole circumstance, because this is the only company in its class. It's the only large ILEC. And I assume they're trying to avoid any competition, but to me, it seems like they are using that notion as a shield to provide information. This is an assertion of mine, but I'm shocked to see how forthcoming they were with the first round of information they were to provide, and how drastically we are lacking in information this time. So I'm concerned about it, and I'm glad to hear that you'll be able to go forward with reaching out. And I approve of the suggestion that I agree with the suggestion that Commissioner Fishman made about reaching out to Legislative Council Service, maybe getting their advice on what's the right way to proceed. But I appreciate you doing that, Russell.
Yes, Madam Chair. I think that's the Legislative Council Service is probably the best contact.
Yeah. Okay, great. All right. Well, thank you very much.
But Madam Chair, what I would like to say though, I would like to just comment. I find it really shocking and surprising as well that CenturyLink, as I noted in the report itself, in 2 or 3 different areas, is claiming confidentiality precisely with regard to more recent information of a type that was provided without a claim of confidentiality, provided publicly the first time around for the initial report. And as I say in the report, there's no explanation.
Right.
So I actually thought that the legislature should know that. That's one reason why I did it this way. I thought it was shocking, and I wanted to point out to the legislature, this is the report we're preparing for you. And CenturyLink doesn't want to provide this information. I actually wanted to emphasize that this fact, the extent to which CenturyLink has expanded its claims of confidentiality. I wanted the legislature to know that. But I do. I mean, I see. I mean, actually, I didn't feel like this was sort of a failure on the commission's part, but this would be the commission pointing this out, making it, quite clear to the legislature, this is what we're dealing with. We will work around it, but this is a redacted report because we were CenturyLink has greatly expanded its claims of confidentiality with no explanation at all. I mean, the same information they had no problem providing for the initial report 3 years ago. They're having a problem with now, and that is truly shocking. And I kind of wanted to emphasize that in the report. But of course, I think I do hear what you're saying about just reaching out to the legislature and getting a procedure in place. When I was writing it, I actually was kind of exercised about this idea that they're doing this. And I thought, I want the legislature to see this. But it's also, again, they really want the information. That's what's most important.
Okay,
So,
Russell, I think that's good. And I noticed that you were pretty straightforward about the lack of information, but sometimes I thought it wasn't quite clear. And if you, at the risk of taking a little time, I'd like to just draw your attention to the places where I thought it wasn't quite clear. And if there was more to add, I wanted to ask you to add it. Could you pull up your second report to the New Mexico Public Regulation? It's, it's that 4-page document.
yeah, I'm in that right now, Madam Chair.
You got it?
Yes.
Okay. Hang on a second. All right, let's see. I noticed you said on page 2 in the second paragraph, first full paragraph, third line from the bottom of that paragraph. So the commission generally undertakes a review of the legitimacy of a claim of confidentiality only when the claim is challenged. And should the legislature desire access to all or part of the information that CenturyLink claims is confidential, the commission stands ready to work with the legislature. That's the part that kind of concerned me at first, because, this is not a litigative scenario here. This is a statute that says the information is supposed to be provided. And so, and we've gone over this already, but I don't think that was the test to use. I think we need to, it's not whether there's a challenge, because we're not in a situation where there is a party to challenge this claim. So we need to be more proactive, but I think we're on top of that now. Going over to.
Well, Madam Chair, I would say this, but because and I think this is what the commission's idea is too, is that we will continue to treat this information as confidential, but we'll find a manner of transmission subject to the protective order that maintains the confidentiality. Not that the commission will go through the documents and decide whether there's a valid claim or not. That's a whole different thing. Once the commission does that, the commission could decide. I don't think the commission would end up deciding that all of the documents are not confidential, because as I noted in the report, some of this information is generally, some types of information are generally considered confidential. But most of it, I think, like I said, it's a change in position that doesn't seem to be justified. So coming up with a procedure would be, because to transmit this information to the legislature confidentially, would be because the commission would be continuing to honor that.
Correct. And
yes. Okay.
So,
one thing I would like to note, though, Madam Chair, is that you're right. You said that most of the claims of confidentiality are probably based on a claim of trade secret, of protected trade secret. And the commission, the New Mexico, like other states, has adopted the Uniform Trade Secret Act, which is a very simple act, but it can be hard to determine what's really a trade secret. Courts come out all over the place on that question. One thing I like to know is that act leaves us, actually does, it does render even agencies of the government liable for providing a document that turns out to actually be a valid trade secret. That's why I wouldn't want the commission to try to determine whether the documents are valid trade secrets or not, because it's simply I've worked in this area before, even before I came to the commission. Courts come out different ways on trade secrets, and what's not so funny but not so funny, is that the commission is often in a very difficult position if it has to decide these questions, because they're not always clear. And if we get it wrong, we could be sued. I doubt CenturyLink would sue us. They continue to be a regulated entity, but they would. But if we got the question wrong, if the commission decided something was not a trade secret and we were sued by the regulated entity whose information it was, then a court could find out we were wrong and find out it shouldn't have been disclosed. On the other hand, and this is a problem in IPRA requests. I just want to point this out because this is a real problem. You know, on the one hand, the commission is liable under IPRA for damages often occurring, I think, daily, for failing to produce a document, even on a claim of, you know, even if it's because the commission has determined something is, say, for example, a trade secret. But if the commission gets it wrong the other way, decides something is not a trade secret, and or decides something is a trade secret, excuse me, the commission just wrongly decides something is a trade secret, then the commission can be liable under IPRA. If the commission wrongfully decides that it is not, excuse me, that is not a trade secret and produces it, and the court says later that was a trade secret, the court can be liable to, commission can be liable there too. I just wanted to point out how
Yes,
there's no room for error on making a decision on that. So it would be best to avoid the decision and just, you know, try to maintain the confidentiality and the transmittal process, which is, of course, what you're suggesting.
Yeah. Okay. Well, I appreciate that. And I think that's, you raised good points, and, you know, it's all more reason to consult with Legislative Council Service to see if they have some methodology in place. That's a good idea.
What I would say, Madam Chair, is if the commission wants to empower me to take these actions, I mean, the revisions to the adding that information back into the second report will not be difficult. The staff, when they prepared their report, draft report, did provide an unredacted version. So if the commission wants to, especially because this is the last meeting, open meeting of the year and of this commission, the commission could empower me to do that. I could just change the order adopting the report to, you know, because there's an instruction there that this report will be transmitted to the legislature by Friday. I could change that language to say, you know, the Office of General Counsel shall do this, shall work with the legislature to arrive at a procedure for transmitting this information confidentially.
Well, actually, Russell, I'm sorry. I see where you're going with that, but no, what I would really like you to do is reach out to them today. Reach out.
Oh, yes, Madam Chair, I would. I just mean, I do need it.
So that when we, don't interrupt, please. If you could just, let me finish. I just want to say, I'd like our report to be able to contain an explanation of what the process would be. I'd like us to figure it out with the legislature if at all possible. I mean, it's important to get it out timely, but I think this is something where it may be that just if you have a conversation, you might be able to solve that problem in the next day or so. To me, it seems like a question of what to protect and what not. And of course, if everything's filed under the blanket of confidentiality, that's the big barrier. And of course, it's too much to parse through. So what you need to do is work out some sort of methodology. And if you can't within, you know, the end of our term, then I guess you can't. And then you would have to contain language in the report that contains that. Or, I mean, I suppose this report could be filed by the next commission, but I think I'm uncomfortable leaving it the way it is, or just containing language saying we will work something out without us at least making a bona fide effort to do that very step in the next few days. I guess that's where I'm at. I just like to see us move forward with that. And I think there's concurrence, or at least no objection to that on the commission right now. So maybe if you could proceed that way. And I've got a few little areas of question, but I could work with you on offline where I just didn't quite understand what you were saying, but we don't need to go through each point because I think it'll take a long time. It can take a long time. And you have other cases that are important that we get to. So
Madam Chair?
Yes, Commissioner Fishman.
Yeah, I think there's room, as Russell suggested, to in the order ask for the follow-up and also do the urgent follow-up that you're talking about. But I think it'd be good for the next commission to have that follow-up in the order as Russell has suggested.
Absolutely.
So I would just move as an amendment to the order. Russell, if you're unless you have objection to that, Russell.
Well, Madam Chair, Commissioner Fishman, my idea was that this wouldn't have to go to the next commission because I could just, I would just be empowered to take the actions that need to be taken.
Okay.
And it wouldn't be, Madam Chair, the order would include that information so that I could, and I would do that. I'd be doing it right away. It wouldn't be any kind of delay. It would just be that I could take care of it by the end of the week, hopefully, or if not, the first week of next year, and the new commission wouldn't have to deal with it at all. But that does involve, making changes to the report. I don't think that they're significant changes because, they're significant, but I don't think there would be a wide divergence of opinion as to how to address it. I just have to plug in the numbers that aren't there. So I could do that without, even bothering the new commission with it. But it's also an alternative is to bring it back for the new commission. So those are the two differences. Those are the two different paths. And I just thought either way, I'm going to be working as my top priority is to transmit this to the legislature or to find out how to do that. But that could be done without another commission having to look at this because the changes are just to add the information that is.
Russell? Yeah.
Yes.
So I'm fine with language that empowers you to take care of it, and then obviously do the follow-up with Commissioner Hall.
I can do that.
That would be my suggestion. And do you have some language you'd suggest for that, Russell?
Yes, I would just say something like the Office of General Counsel is instructed to draft or to amend the report to include the information that has been redacted or withheld on the basis of confidentiality, to contact the legislature, including the Legislative Council Service, and I'll also contact the committee to which this is going to be directly transmitted, to put in place a procedure for transmitting the unredacted amended report to the legislature while honoring the claims of confidentiality of the information. I think that's it.
Madam Chair.
Yes, Michael
Just
Smith.
inquire one thing. Russell, can you hear me, Russell? Russell?
Yes, I can.
Okay, so one hurdle that, and I don't know your confidential, I'm not familiar with your confidentiality order in detail, but does your confidentiality order that is in place, your protective order that's in place, provide for or have room for you to take an action like that, or do you need to go back and revisit your protective order?
The protective order that was entered was the one requested by, was actually what was requested by CenturyLink. So I would hope, and this is the whole purpose of this, is to transmit to the legislature. And it's similar in form to the commission's standard protective order, which allows for parties to sign confidentiality agreements. But I think that I believe there's other language in the order, recognizing this is a different type of proceeding. I hope it mentions the legislature by name, but let me take a quick look. I don't think that is going to be a problem because it is. I recall that when I was reviewing it, I made sure that it was more generally written, that even though it was modeled in relevant ways on the commission's standard protective order for adjudicated cases, that it wasn't, that it didn't have the language that would end up limiting it in such a way that it wouldn't be useful. So, but I can find it. It's possible, Mike, do you recall, Mike Ripperger, do you recall the, whether the protective order provided for transmissions to the legislature? I can
No,
quickly
Russell, I
find
do
it here.
not. The only thing as you recall, is that some protective orders have certain mechanisms for built into them for challenges of confidentiality. Others are more designed for like reports where it's pretty much a submission of information. It's less specific. I think this is in the less specific category. But I don't remember anything in that protective order. I'd have to go back and review it. But I don't remember any mechanism for transmittal to the legislature.
Okay, yeah, I'm looking at it now. I'm looking at it right
Madam Chair.
now.
Is that Commissioner Vicente Aguilar? Did you have a statement?
Yes, thank you, Madam Chair. While Russell is searching for information, I just like to just chime in. This is the telecommunication carrier that is making a bold move at the final hour of our work here at the commission. If it means that we need to regroup again at the final hour, I am available, because I want to walk away from our work knowing that we have a very huge concern for this protective order. And I would like to document that according to how the General Counsel's office is the best way to protect the commission. And the other telecommunication carriers around the state of New Mexico, I believe that they're working diligently to provide service fairly. And for CenturyLink to come in the final hour with this type of an action, then we need to take action as well from the commission, because public needs to know, the legislature, they need to know that protective order is not really something that we can just walk away from. And that's my comment, Madam Chair. Thank you.
Thank you, Commissioner Vicente Aguilar. I really appreciate your sentiments here. Okay.
Madam Chair, Commissioners, if I could just chime in a minute. And Russell, there does appear to be a section in the protective order about challenge of confidentiality. I think staff definitely did discuss this protective order. And I think our decision was to discuss it in the report itself. Maybe that was the wrong way to go about it, but that's what we did.
Well, again, no, I'd like to say this is not about a challenge. This is not about challenging the confidentiality. It's just about whether the protective order, the protective order expressly, like other protective orders that our standard protective order, says that, when something's filed confidentially with the commission, it's the commission the commission shall have access without having to sign anything. Staff shall have access. That's in a non-litigated case. Of course, if staff is a party to a case, then they have to sign confidentiality agreements as well. And OGC has access. This doesn't say anything about the legislature. But I don't think it's surprise. All I need to do is find out the procedure and have confirmation from CenturyLink's attorney that that will be acceptable to them, and that that can be part of the record in this case. So all we have to, it just has to be satisfactory to CenturyLink, the transmission to the legislature. If it is, if we, find out the legislature, how the legislature usually does this. If it's satisfactory to CenturyLink, then I can go ahead and do it. I'll just have something in writing, just by email from their attorney authorizing that. If they don't, then I certainly will be before the next commission, noting that CenturyLink doesn't want to provide this information to the legislature. But I doubt that's what's
Russell,
going to
could you
happen.
speak a little more slowly? I'm losing.
Oh, I'm
some
sorry.
words and I'm not really
I'm sorry.
following everything you're saying.
I apologize, Madam Chair.
Just
So I can take, again, I can be empowered to take care of this issue as well, because what I'll need is CenturyLink's acquiescence to whatever method of transmittal to the legislature that I am informed of by the legislature. CenturyLink, I'll get something in writing from CenturyLink's attorney. I get even an email we can find, just something in the record that shows that once we know what the procedure is, CenturyLink is satisfied that that is satisfactory to protect the confidentiality of their information. I mean, seriously, just an email from their attorney will be sufficient, and it will be placed in the record. And I'm assuming that they will agree to that. I'm assuming
Russell,
that
let
they
me ask you a question here then. I hear what you're saying about transmittal of information to the legislature, but what about their tables and that sort of thing? I would hope that we'll be able to see the information, and maybe you know this already if you have seen what they've submitted, if they have updated the tables and so forth and graphs that they prepared in the last report, because I would like for the legislature to be able to see visualization of the data they're presenting in the same way they did in the last report. And I think that's also going to affect some of the phraseology in some of the parts of our report. For example, we have, when you're talking about Exhibit G, where CenturyLink's investments in telecommunications infrastructure needed to be reported, you're saying the commission, we're saying, I guess we don't have the information beyond 2018. And you say the commission notes that as essentially all infrastructure investment made by telecommunications carriers today includes broadband infrastructure. These broadband infrastructure investment figures should serve as reliable proxies for CenturyLink's investment in telecommunications infrastructures. I'm uncomfortable with drawing that equivalence if we don't have real data that supports that. So I wouldn't want our report to be looking like we're guessing when we don't have proper information, but if the
well, Madam Chair, I can clarify that.
Let me finish. If the information can be provided by the company, then maybe somehow our phraseology that can be a little bit more specific to the newer information in our report. What do you think?
Madam Chair, actually, let me parse that out. Okay, so first of all, these tables were actually prepared by staff, just as they were for the initial report. And staff has prepared versions that include the information claimed confidential. In other words, the information for the years 2019, 2020, and 2021. So if the commission,
I say that's
if the commission were to empower me to revise the report, I'd be including those tables. And then the content of the report that refers to the tables would simply say, this is, the tables attached show that information through 2021. The issue that you raised, ma'am.
Wait. What would you say? I didn't quite follow that sentence.
Well, I'm sorry, also.
It staff empowers you to do what now?
If the commission today empowers me, as Commissioner Fishman was discussing, to go ahead and add the information that we do have from CenturyLink, the updated information for the most recent 3 years, the information that they are claiming is confidential. I will have the tables ready. Staff actually is prepared 2 versions of the tables. You're seeing the redacted ones. So I would just be adding those tables. And then within the body of the report, the references to those exhibits, would be changed just to say, this information is provided through 2021 and describe any trends just briefly. That'll be it. I'd be able to do that because we have the information. The other point, Madam Chair, about the usefulness as a proxy of the information that CenturyLink has provided is not as divorced from the issue of confidentiality, because we included the same statement in the initial report. The issue there is not the specific information. The issue is that what CenturyLink has provided, both with regard to the initial report and with regard to this report, whether provided confidentially or publicly, is not exactly what the legislature asks for in the act. The legislature asks for information on telecommunications infrastructure investment. And what CenturyLink provided in the initial report, and we transmitted to the legislature, and what CenturyLink is providing now confidentially is information concerning CenturyLink's investment in broadband infrastructure. Now, the reason the commission accepted that the first time around for the initial report and should accept it this time around for this report is that staff noted in their draft report, and I incorporated it into this report, that broadband infrastructure investment is a very good proxy for telecommunications infrastructure investment, because essentially all infrastructure that's being deployed today by any telecom carrier is for both. So that was the point, is that if you looked at that was the point. If the information that was sent by CenturyLink in both instances, for the first report and this report, is actually information on investment in broadband infrastructure, not investment in telecommunications infrastructure, which is what the act calls for. But it's perfectly fine, because that information is going to be essentially identical, because all investment in infrastructure by carriers today is capable of both.
Okay, then I think the report should state it that way, that they are essentially identical. The way it's worded, it doesn't give you it doesn't give me anyhow any clue about how much of the broadband infrastructure is included. You say telecommunication carriers, investments made by telecommunication carriers today include broadband infrastructure. But if there's an equivalence in this case, we should say that, because otherwise, when you say these broadband infrastructure investment figures should serve as reliable proxies, I think what we want to say is, in this case, they do serve as reliable proxies. There was just an uncertainty.
I'm sorry, Madam Chair, we don't know that. That's something that we didn't know the first time around and wouldn't know this time around, because we'd essentially have to then ask them for essentially is all of this investment in infrastructure, investment in broadband infrastructure that is also capable of voice service. That's something we would have to do. And I think the point was that CenturyLink is correct in saying that, in providing us broadband infrastructure numbers instead, because that's how they collect the information. That's what they're really working on, and most carriers are, and that infrastructure is generally voice capable, period. And that we are not verifying that. We didn't verify that the first time around, but we feel it's a safe assumption I don't know, Mike Ripperger might want to weigh in on that.
Well,
But I think it's a safe assumption too. Yes.
I think all you need to do is just phrase it in a way that sounds more knowledgeable, because the way it read, the way it's written now, I think it just, I think it left me to wonder whether or not we had any data supporting the inference we were drawing. But if you can phrase it in a way that more accurately reflects your informed assessment, then do it that way. I think it's a matter.
Madam Chair, I hear you. Yes. Yes. And I just want to make clear. Yeah, we would not have any specific data to tie those two things, because essentially the idea is this is how the company designates this information. It's how it collects the information already. And that's the idea. The notion is that's perfectly fine, because generally we know carriers today are, in fact, that's what it says. Essentially all infrastructure investment made by telecommunications carriers today. So it's based on a broad assumption, but a very good assumption that this is true of all carriers. We don't need to specifically look into it in this instance, because this is just the rules of the road, the facts of infrastructure investment today. Mike, would you say that's correct? I think I copied directly from staff's draft report, which is exactly what we said in the initial report as well.
Yeah, I mean, these networks are intertwined. Generally, you've got more of the IP network and less of the TDM network continually over time, but they function to do pretty much the same thing. You may have a copper loop at the end, but all that IP infrastructure is working to maintain the intrastate communications. And so the act of doing an absolute separations, which is what they may not do anymore, would be a very, very large exercise. I think the proxy is not off. I think it's appropriate, and I think that it's okay to use that in this instance. Okay,
that's great. As I say, just phrase it in a way that sounds like you know what you're talking about, and I'll be satisfied. Okay, I think we're done with this, unless other commissioners have any other comments. And Steve, can you, were you making a motion at this point or not? Commissioner Fishman.
You're muted.
Yep. Unfortunately for you, I am unmuted now. But Russell, and Madam Chair, I was suggesting adopting an amendment giving Russell the authority to follow up on the issues that we were just discussing. And Russell, you'd proposed language a few minutes back, which I was fine with. Based on all the discussion that you and the chair just had, is that amendment still relevant?
Commissioner Fishman, yes, because the order would empower me not only to immediately look into how to transmit an unredacted version of the report with complete unredacted tables and complete unredacted references within the report to the updated information. It would also allow me to consult with Madam Chair on minor changes that she's brought up in addition to the updating. So yes, that language would empower me to do everything I need to do.
So I would move that amendment and ask you, Russell, to read it out again and see if it merits a second.
All right, so let me type this as I say it. Okay, so in the ordering paragraph should say the Office of General Counsel. I know I am typing this, so I will be speaking slowly, as I apparently should be doing anyway. The Office of General Counsel is instructed to, number 1, prepare an unredacted version of the second report, including the information referenced in the report as withheld under a claim of confidentiality, including unredacted exhibits. 2, in other words, the second instruction to the Office of General Counsel be to contact the Legislative Counsel Service as well. Let's say, contact the Legislative Counsel Service, the Science, Technology, and Telecommunications Committee, and any other necessary personnel, I'll say, at the legislature to determine a satisfactory method by which to transmit the unredacted version of the second report to the legislature. And then 3, inquire of CenturyLink's counsel as to CenturyLink's acquiescence to such a procedure for transmittal, and if CenturyLink is agreeable, file in the record of this matter the written authorization from CenturyLink, which could just be an email.
Okay, I have a question.
Yes, Madam Chair, yes.
So, okay, this would authorize staff and the commission to transmit an unredacted version of the information provided by CenturyLink, covering the relevant time period up to 2021, between 2019 and 2021. And when you said method, in paragraph 2 there, the purpose of the method is to provide some confidentiality protection, right?
Yes, that's correct, Madam Chair.
You might want to add a clause for the purpose of a method for purposes of maintaining confidentiality.
Oh, a very, very good point. So yeah, I'd say contact the Legislative Counsel Service, the Science, Technology, and Telecommunications Committee, and any other necessary personnel at the legislature to determine a satisfactory method by which to transmit the unredacted version of the second report to the legislature while maintaining
Confidentiality.
the confidentiality of the information. Yes, yeah, exactly. That's a very good point. Thank you, Madam Chair.
Okay. All right, fine. Thank you very much. And you think this is something you can get done in the next couple of days?
Yes, yes, I don't think it should be a problem at all. It's after Christmas, so I assume there'll be some people available at the legislature, and they probably do this quite regularly. I'm just not familiar with the
Okay.
process.
Okay, super. Great.
So
Thank you.
Madam Chair, just now that Russell's read it, I will move that motion.
Okay. All right, we've got a motion. I need a second.
So, Madam Chair, is that a motion on the amendment or the entire report with the amendments to the proposed order?
I would move that as the entire report with the amendments.
Okay. I'll second that.
Okay. All right, we've got a motion and a second. Mike, can you take the roll? Or discussion, any further discussion? What's that? Oh, okay. Commissioner Vicente Aguilar, any further discussion?
No, Madam Chair.
Okay, thank you. All right, Mike, can you take the roll?
Commissioner Byrd. Aye. Commissioner Maestas,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Hall,
Aye.
Commissioner Fishman.
Aye.
Motion passes 5-0.
Okay, great. Thank you very much. Commissioners, I'd like to propose we take a 5-minute break. And we'll reconvene at, let's see, it's 11:03. Well, let's come back at 11, now it's 11:04. Let's come back at 11:10.
Okay.
Yeah. Well, around. I'm hoping that. Yes. No, that's not what oh, thank you. No, I almost stayed here.
think you're live now, Madam Chair.
Okay, I'll read over that again. We're now on item number 4 on the regular action items. Is case number 21-00064-UT in the matter of the application of El Paso Electric Company for a variance from the fuel and purchase power cost adjustment clause methodology. Russell Fisk is going to present a potential order regarding recommended decision. So Russell, are you ready to proceed again?
Yes, Madam Chair. So I'll be going through the memo that I provided, and it is a long memo, but I can make it more succinct, and I will do that. First thing I would like to note, which I failed to note in the memo, is that due to the exigency of getting this matter done by the end of the year, so that it could be decided by this commission, who after all has been in place during the events that are at issue here, Winter Storm Uri in February 2021. I deviated from the procedure that the commission has generally adopted with regard to opposed RDs to which exceptions have been filed. As the commission will recall, the commission has generally adopted a procedure by which there are 2 sessions, there are 2 open meetings at which such an RD would be discussed. One would be a closed session involving the hearing examiner just for discussion purposes. And then there'd be the next week under that procedure, a discussion at the open meeting that would just involve OGC, and it would be discussion of the exceptions and the recommendations of OGC regarding those exceptions. Here, I'm going to do the whole thing today in open session. So it appears that Bob Lennon actually is on this this Zoom meeting. I wasn't sure if he was even available because I simply told him I'll take care of the whole thing because he found out that we wanted this done by the end of the year, and he very helpfully made that happen. So I have a good grasp of the RD, so I think I should be able to do it without having to refer to Bob Lennon at all. Or to refer any questions to him, excuse me. So this concerns, as I said, a motion, or as it's referred to in the docket, an application by El Paso Electric Company for a variance from its fuel and purchase power cost adjustment clause methodology. As the commission will recall, that's something that gets approved by the commission. That's the fuel clause. The methodology for passing through the costs of fuel and other costs is something that gets approved by the commission and is reviewed at least every 4 years. So EP, of course, has such a fuel clause in place, and they ask for a variance, as many other companies did, with regard to February 2021, which is when Winter Storm Uri, the storm which caused New Mexico and Texas to experience extremely cold temperatures, and which coincided with extremely high spikes in the cost of natural gas that affected, I think, all the utilities, the co-ops, et cetera. The commission will recall there were hearings held before the commission regarding some of those requests because the applicants and EPE is the same in this sense. The wanted to avoid an enormous increase in the fuel that would otherwise an enormous increase in fuel costs that would be otherwise transmitted directly to ratepayers all in 1 month for 1 month's billing for February 2021 to customers, which would be extreme rate shock. As the commissioner will recall, natural gas prices really spiked. Now, EPE is in a slightly different situation because EPE did not actually purchase natural gas at those high prices with regard to their request for variance. I'm not certain that they didn't purchase gas at a higher price for their grid at all, but what they've described in their motion for variance is incremental additional costs caused by Uri of $6.8 million resulting from Uri for the 1 month for February. And where we stand now is that the commission approved back in 2021 an adjustment to the fuel clause for February 2021 to exclude these incremental increased fuel costs of $6.8 million so that they could be considered in this proceeding. So what happened in the bill for the billing for February 2021 is that the fuel clause costs were passed through the fuel costs, but they didn't include these $6.8 million in incremental increased fuel costs, which went into this proceeding. So in the motion for variance filed by EPE asks that it be allowed to pass through these increased fuel costs to customers over a 12-month period, basically a smoothing period to reduce rate shock. So they don't see that at all on a single monthly bill. And there are two questions. One, I think a fairly simple question as to whether a 12-month period is sufficient as a proper smoothing period. And I think a 12-month period is what was generally adopted by the commission with regard to other similar requests regarding Uri. But there was a dispute in this matter as to whether the commission had scoped this matter when it sent it to a hearing examiner to include a review of the amount and propriety of the costs themselves. In other words, EPE has argued that when the commission assigned this to a hearing examiner, the commission limited it to the question of just whether 12 months was a proper period for smoothing the adjustment, smoothing the passing through of the $6.8 million in incremental costs, which the commission's order the proposed order would say, no, that's not the case. I think it's quite clear. And it was quite clear to the first hearing examiner who had this matter, that was Carolyn Glick, now retired, that of course we're actually reviewing the costs themselves as well. And so I will note this, the hearing examiner did in the RD seem to adopt this idea or agree with the idea that this proceeding was limited to reviewing whether the 12-month period is proper and not reviewing the propriety of the $6.8 million in increased fuel costs. But the hearing examiner actually did undertake that analysis anyway. The hearing examiner did review what EP had done, chosen to do what I'll describe in a moment. I think properly. And so despite the fact that there were some statements in the RD to the effect that that was outside the scope, the RD does that. It actually does that analysis, and my proposed order would adopt the analysis of the RD with regard to the propriety and the amount of the incremental increased fuel costs. What's at issue, what is disputed among the parties to this matter is not the entire $6.8 million, but $5.7 million of that, obviously most of it. what EPE did in the face of the crisis in the natural gas market in February 2021 was that EPE chose to employ Palo Verde nuclear generating station unit 3 as a resource instead of purchasing natural gas on the market at extremely high prices. Now, the commission will recall, possibly from the most recent rate case, that that particular unit, Unit 3 of Palo Verde, the EPE's interest in that unit is not has not been, the EPE has not been granted a CCN, a certificate of convenience and necessity for that unit. So it's not in rate base. It's not generally approved for use by EPE as a to serve New Mexico customers. Presumably it serves Texas customers of EPE, but there is a special arrangement that was in a stipulation in a previous case, which goes back before 2009, but it was restated in a 2009, I believe it was a rate case, might have been a fuel clause case, with regard to the circumstances under which EPE can make use of Palo Verde Unit 3, despite the fact that there's no CCN for that particular facility. So that stipulation also provides the proxy price for the energy and capacity, the value of the energy and capacity that will flow through the fuel clause when EPE properly uses energy from Palo Verde Unit 3 to serve customers in New Mexico. And the problem is this, I think, for the interveners and staff as well, is that the proxy price is not based on the cost of the nuclear, basically the nuclear generation, the nuclear, I'll say fuel, for lack of a better word. It's not based on the actual cost, as it would be if there were CCN and the EPE were authorized simply to flow through the costs of an approved rate-based asset through the fuel clause. That's not the situation here, and instead, the proxy price is based on, unfortunately, largely natural gas prices. So the use of Palo Verde may have, did avoid EPE having to go out of the spot market and purchase extremely scarce natural gas at extremely high prices. But some of the elevation, or maybe much of the elevation of the prices, was actually reflected in this $5.7 million in increased incremental fuel costs for Palo Verde, even though Palo Verde is a nuclear source, because the commission specifically approved this proxy price, which is based on a sort of index of natural gas and possibly other prices, prepared by the investment bank Credit Suisse. That's been the proxy price that's been in place since at least 2009. And that is, so let me get to what the interveners and staff have to say about that. So staff takes exception to the RD, because the RD would grant the motion by EPE and say, the RD found that, as my proposed order would find, that the proxy price is the only price. If it was proper for EPE to make use of this this Palo Verde Unit 3 in this situation, then they should be compensated at the proxy price, because this is a special arrangement, not based on actual costs. It's something that's been in place as per the approval of the commission. If this is passed through to customers at all, if it was a proper decision made by EPE to use this resource, then the proxy price is what applies. And the RD found that it was a proper choice by EPE, and so would allow that $5.7 million, along with the undisputed portion of the $6.8 million in increased fuel costs due to Uri through the fuel clause over a 12-month period. And that's what my proposed order would do as well. Staff takes exception to the RD, arguing that the requested variance, and now if you want to follow along, I'm on page, page 2, I believe. Page 2, yes. So at the top of page 3, I'm sorry. Let's see. Oops, page 2. Page 2. Okay, staff takes exception to the RD, arguing that the requested variance would result in an unexpected windfall to EPE, I'm quoting now, which, unlike the other electric utilities in New Mexico, was not forced to purchase gas at the extreme high prices created by Uri.
Russell, excuse me, what paragraph are you in?
I'm sorry, I'm at the top of page 2, where the discussion of the exceptions, I'm sorry, it's actually not the absolute top, where it says staff's exception.
On page 2 of the
memo. I'm sorry, page 3. It is page 3. I'm sorry about that.
all right, which paragraph now?
Sorry about that. That's page 3. So where it says the exceptions and then it says staff's exception.
Okay,
That's where. So
Okay.
now I'm on paragraph 3 of that subsection.
thank you.
So staff states that EPE's requested $6.8 million in incremental New Mexico jurisdictional FPPC-CAC, in other words, fuel clause costs, includes $5.7 million of incremental Palo Verde Unit 3 charges that it claims were due to Uri. Staff says, unlike other utilities, which had to purchase gas or electricity from suppliers at inflated costs to be able to continue to provide service to their customers, EPE was able to utilize Unit 3 already in its portfolio to serve its customers. Staff argues that applying the proxy price to value the 42 megawatts of energy provided by Unit 3 during the natural gas price crisis caused by Uri would result in customers being charged an additional $4.4 million in incremental fuel costs that could be avoided if the market price for Palo Verde energy and capacity were applied instead. So staff is saying that of the 5.7 million of incremental charges for the use of Unit 3 during Uri, based on the proxy price, using the actual market price of that particular energy, the nuclear energy and capacity coming from Palo Verde, would avoid $4.4 million of that 5.7 million. Staff acknowledges that the proxy price for energy and capacity from Unit 3 is outside the scope of this proceeding. However, staff argues that it is not challenging the determination of that proxy price, but rather that the use of this price by EPE in this proceeding is an avaricious attempt to gouge EPE customers for fuel or purchase power that the company did not have to purchase. Staff recommends that the commission apply the market price for Palo Verde energy, Unit 3 energy and capacity identified by staff's expert witness, Gabriela DeShenio. I hope I'm pronouncing that correctly. If I'm not, please forgive me. Resulting in an incremental fuel cost of $1.3 million instead of $5.7 million. And staff provides an alternative recommendation in the event that the commission agrees with the hearing examiner and determines that it has no choice but to allow EPE to collect this egregious windfall. Staff's alternative recommendation is that the commission open a proceeding to revisit EPE's authorization to continue its fuel clause. Staff argues that the commission is not required to continue an adjustment clause that allows EPE to collect a jackpot from its customers when weather conditions artificially inflate the proxy that EPE uses for its fuel costs. So staff has two alternative recommendations. Now, as I noted in my memo, as you can see from the order, I've actually combined the discussion of all of the exceptions, staff's exception, the 4 exceptions filed by the city of Las Cruces, and the 3 filed by Marilee Souls, because they're all interrelated. I'm going to make an exception here, though, because I would like to first address how the proposed order would address staff's exception, because staff does have has these 2 recommendations are unique to staff. So with regard to the first recommendation to use a market price for the actual energy that was used, Palo Verde Unit 3, that's not an option. The commission would find that's not an option. As I just said, there's a special arrangement for the use of this energy. It's not approved for general use in terms of in the sense that it's not. There's no CCN, so there's no authorization to simply pass the actual costs of that energy, and no authorization to use the market price for that energy. There's only the authorization for EP when they use that energy to use the proxy price. So that's just not an option. The second recommendation by staff, the proposed order would find that it's moot. The commission doesn't need to take any action to avoid the proxy price being charged through the fuel clause in the future, because in the commission's order in the most recent EPE rate case, which is, sorry, I have the number here. I don't have the number in front of me. Issued in 2021, the commission found that EPE is no longer authorized to use Palo Verde energy from Unit 3 at all, because the special arrangement was subject to a stipulation of the parties in a past case, and neither an EPE did not want to go forward anymore under that arrangement. It wanted a different price other than the proxy price, one that actually did reflect the costs of the nuclear energy. And the commission found, well, this special arrangement was only in place because it was agreed to in a stipulation. And as you recall, stipulations, there's more, let's say, wiggle room for the commission with regard to legal standards that are not considered major, major regulatory policies, to deviate and allow something that facilitates a stipulation. So that's what the commission did in the past. But there was no stipulation. There was no agreement in the most recent rate case. So there was nothing for the commission to work with in
Russell,
terms
I
of
have a question.
Yes, Madam Chair.
What you were just saying there about the commission's authority from a stipulation and wiggle room and so forth, are you just referring to the fact that stipulated agreements are often just applied just to that set of facts and don't have precedential value? Is that what you're talking about?
Well, that's a good point, Madam Chair, but that's not the point I was making. The point I was making is that, and I'll use the analysis of this particular issue to illustrate it. The law generally is that, the commission, if a particular facility that's owned by a utility is used to serve customers, it can only be used to serve customers pursuant to a CCN that's been granted by the commission. And that's actually what the commission states in its rate case order from 2021, is that there's no special arrangement in place anymore. So it's the law that applies, the CCN law, law regarding CCNs. And that's why the commission told, said in that order, if EPE would like to use Unit 3, they're going to have to come in again for a CCN, which has been denied them in the past. So generally, that's the law. With in the absence of a stipulation approved by the commission, the law is if you don't have a CCN for a facility, you're not passing the cost through to customers, period. It hasn't been approved for use to serve these customers, specifically New Mexico customers. But in the case of a stipulation, there are a number of not factors, but a number of requirements of elements that the commission must find in order to approve a stipulation. That it was an arm's length agreement, that the parties were represented by competent counsel, and when it comes to the law, our standards for approving a stipulation actually say that no major regulatory policy or and if anyone else from OGC remembers exactly how this is phrased, I would encourage them to pipe in. But it actually is no major regulatory policy is violated by the stipulation. In other words, you can deviate from how a strict application of the law would operate, because this is that's one of the points of having a settlement among the parties, is that they're able to agree to this. But because the commission also protects the public interest, the commission has leeway to approve a stipulation that provides for a situation that otherwise would not be allowed under the law, because it's not violating a major regulatory policy. Does that make sense? Did I explain that?
Yeah.
Okay.
Thank you.
Okay. And so since there was no agreement and EPE didn't want to go forward under the old agreement in the rate case, the commission simply said, you can't use Palo Verde Unit 3. There's no special arrangement in place. You don't want the old arrangement, and you need a CCN. That's the only way to do it. So staff's recommendation to review the fuel clause generally because of this issue, so it doesn't happen again in the future, is moot. It's not going to happen again in the future, period. So with that, I will move on to,
Russell?
Yes, Commissioner.
What was the timing of, I can't recall the timing on the rate case decision. Was that before or after Uri?
Before or after? I'm looking at the date of that right now, but I didn't understand, Commissioner Fishman, the before or after, what was that?
Did our final decision on the rate case come down before Uri or after Uri?
Okay, very good point. It came down after Uri, so the arrangement was in place right up to the issuance of the order in the rate case. So yes, the Uri was covered by the old arrangement.
Okay.
Yes.
A couple other quick questions, because I want to clarify, if not for the commission, at least for my constituents. Because of low fuel costs, the formula was not working out well for EPE. They felt they were losing money on the arrangement. And that's why in the rate case, we came to kind of the stalemate that we wound up with. Is that correct?
Yes, Commissioner Fishman, that's a good point.
So when gas prices were low and it was unfavorable to EPE, they stuck with the arrangement, at least until the rate case. And kind of what staff is recommending is going, well, gee, when prices spiked, now the arrangement doesn't count anymore. And I really appreciate staff's concern there, because that was my initial reaction as well. But gee, I do have to say that when it wasn't working out financially for EPE, they stuck to the agreement. And, you know, it seems odd that you just pick this one little place where suddenly you go, oh, now it's a ripoff, and now we throw the agreement out. And it seems to me kind of arbitrary, you know, that we could do that, arbitrary in an illegal way. Would that be a correct assessment?
I'm hoping I'm understanding. I mean, I understand the issues that you're talking about. I'm not sure exactly what you are taking issue with.
Well, I'm not taking issue. I'm just saying, you know, as a matter of fairness, when they were losing money, they held to the agreement, and now when they got a windfall, they still want to hold to the agreement. That's not necessarily egregious behavior on the part of EPE. They're just holding to a contract.
Yeah, I would agree, Commissioner Fishman. You're right. I think, and what you're pointing out, you know, it's an interesting point because the rate case decision final order had not yet come down during when Winter Storm Uri occurred back in February of 2021. Exactly. So the proxy price was in place, and so it's reasonable for EPE to ask to be compensated that price. But at the same time, they were asking not to go forward with that price in the future. In the rate case, they wanted a price that generally, as you're saying, would be higher than natural gas prices, which is the actual price of the nuclear energy. But that month in February, there was nothing higher than natural gas prices, so it really did benefit. You know, the price is much higher based on gas prices on the proxy price. So yes, absolutely.
But I don't find that behavior nefarious or tricky.
I don't either, Commissioner Fishman, because one was, you know, what do we apply for February 2021? Well, what was in place, the proxy price, and it's perfectly fine for EP to seek that in the future they wouldn't. They would have a different price, but without a CCN, we couldn't charge anything else if no one else agreed to it. So they can't provide that energy at all.
Right, and I'd also say I don't necessarily find it nefarious, tricky, or unfair, because they were taking the hit and sticking with the contract when they took a hit, and they're sticking with the contract when they get a windfall.
Yes, absolutely.
So whether it's up or down, you know, it seems to me that, you know, there's nothing particularly unfair about what they're proposing. So
yes,
I just wanted to point that out.
It's sort of it takes your chances sort of thing. As you were saying, when the stipulation was entered into to use natural gas prices, that may have, back in 2009, you know, that may have seemed like the most economical, may have been the most economical choice for customers as opposed to the actual cost of the nuclear energy. But in February 2021, there was nothing more expensive than natural gas. Possibly even.
But I do want to say I appreciate staff. You know, they're looking out for the consumer here, and I understand where they're coming from. I don't agree, but I understand the sentiment behind it. Which
yes, I agree as well. I agree as well. And as I was preparing this matter, I was trying to think: is there any way that could be applied? And I didn't find any way. I think the hearing examiner was correct. So I'll try to compress this discussion of the other exceptions, because the exceptions filed by the City of Las Cruces and Mary Lee Souls, there's some overlap, and basically they go to the point first of what is the scope of this proceeding. Does it only concern the 12-month, the use of a 12-month period as opposed to, say, a 16-month period? For spreading the costs, the incremental costs of Uri through the fuel clause. And the city argues that the procedural order Actually, I'm on first. I'm looking at the city's exception number 2 first because it's procedural. It's I want to address that first. It's at the bottom of paragraph of page 4 of the memo. So the city takes exception to the RD, arguing that the hearing examiner, quote, ignores the scope of proceeding established in the procedural order. This is a procedural order issued by Carolyn Glick, the initial hearing examiner.
Oh, excuse me, where are you reading again now?
I'm sorry, I'm on CLC. That's City of Las Cruces exception number 2 at the bottom of page 4 of the memo.
Yeah, got it.
Okay, sorry about that. The city takes exception, arguing that the hearing examiner ignores the scope of proceeding established in that procedural order that required EPE to demonstrate that Unit 3 at an incremental cost of $5.7 million was the lowest reasonable cost power available, which was actually stated as a standard in the procedural order. The city states that tracking the terms of the joint report, and this is going way back to I think it was March of 2021, before when the commission was deciding how to handle this particular motion, which of course was to be decided on an expedited basis, which is obviously not what happened here. There was a joint report filed by all the parties to this matter, the interveners and EPE, about how to proceed with regard to this fuel clause issue. The commission, as you will recall, the commission was taking care of other fuel clause issues very rapidly at the time, with hearings before the commission generally. So the city, when it refers to this joint report, is referring to this that was filed before, it's filed by the parties before there was a hearing examiner appointed. So the city states that, quote, tracking the terms of the joint report, the original hearing examiner issued a procedural order and notices to customers that identified the scope of the hearing to include the recovery of the incremental costs and the proposed 12-month recovery period. The city adds that the initial hearing examiner explicitly ordered EPE to file testimony demonstrating that its use of Unit 3 power was the lowest cost power available to EPE to serve New Mexico customers during Uri. I've already addressed this a little bit. I agree with the city that that's part of the scope of this proceeding, the propriety of using Palo Verde during that period, whether it was a choice that took into account alternatives. Was it really the lowest reasonable cost power available? I agree that is a question here. But as I said before, even though the hearing examiner did and the RD make some statements to the effect that he would not be considering that issue, he actually did. He actually did the analysis that I provide, say that I would have the commission adopt in the proposed order. So I think in the end, that's not much of an issue because the hearing examiner did address it. But the record may not have been fully developed in that area. So I'll get to that later. So I agree that the scope includes the proposed order to have the commission agree that the scope includes the propriety of that choice based on, were there lower cost options available at the time during Uri, which is possible that there weren't, but certainly it's not outside the scope of this proceeding.
So, Madam Chair.
Yes, Commissioner Fishman.
So, Russell, what happened there is they wanted to do some discovery, and that discovery, the city wanted to do some discovery, and that discovery was not permitted. Am I understanding that
yes,
correctly?
I believe that was the case. So yes, Commissioner Fishman, yes. Please, I'm sorry, please proceed. I don't mean to interrupt.
Oh, okay, so my question is, can I follow on Steve with that question? Which proceeding are we talking about? The hearing examiner, Lennon?
So, yeah, so let me. No, so I'm saying that the city of Las Cruces on this case, 00064, wanted to do some discovery as to whether Palo Verde 3 was the least cost option. And the hearing examiner said no. And I just wanted to clarify that that's what happened. And Russell agreed that that's what happened.
Yeah, yes, Commissioner Fisher and Madam Chair. And that's why I said, the record may be considered not to have been fully developed in that area. Although the reason I still am proposing adoption of the hearing examiner's recommended decision, despite the fact that that was not developed in the record, is that, and I'll get to it in more detail. There's the stipulation for Palo Verde Unit 3 actually provides a very broad authorization to EPE to employ that particular that particular resource, and it seems to make a definitive finding for all time that Unit 3, the proxy price for Unit 3, is in all instances the lowest cost option. I'm previewing that. Maybe I should go right to it because I'm going to have to get to that anyway. And this discussion has probably been long enough already. Let me just before I do that, let me just say then that let me just summarize the cities and Merrily Souls exceptions as, one, this issue wasn't developed because the hearing examiner found that it was not within the scope of the proceeding, though he did proceed to an analysis of the use of Palo Verde under the stipulation, which was an analysis of the question, but only some might say a partial analysis. That's not satisfactory to the city of Merrily Souls because they were not allowed to develop the record as to what the actual alternative options were, which is certainly a part of the determination of the least cost alternative available to EPE. And I think I'll move on. I think that really does cover those exceptions. I'm taking a look at the exception. I want to be sure I don't miss anything, but that's generally what was objected to by the city of Merrily Souls. So why am I recommending that the commission adopt the RD if the RD did not include all of the information that the intervener sought for determination of what were the alternatives and were they of lower cost actually than the use of Unit 3. Let me see where I am. Let's go to page 7 because I'm going to be reading from the findings in the proposed order. So at the bottom of page 7, where the proposed order is discussed. The first paragraph there that you see there indented on both sides because they're quoted. The commission agrees with staff, the city and Ms. Souls, that the scope of this proceeding is not limited to the determination of the time period over which to spread the incremental costs of fuel incurred due to URI. The amount of the
Russell, where are you again now?
I'm sorry, I'm bottom of page 7 of the memo. You see where it says in the middle of the page, it says the proposed order. And I'm skipping down to the paragraphs that actually quote from the findings of the proposed order, which are indented on both sides.
Yep.
Okay, so it would state, as I said, the commission agrees with staff and the interveners that the scope is not limited to the determination of the proper time period. In other words, the 12-month issue. The amount of the incremental costs that should be passed through the FPPCAC, the fuel clause, to customers is an issue that must be decided in this proceeding as well. However, despite language in the RD indicating that this issue would not be addressed as part of the hearing examiner's recommendation to the commission, The hearing examiner actually does address this issue in the RD. The hearing examiner provides an accurate history of the specially approved arrangement for the use by EPE of Unit 3 to serve customers, as well as the calculation of the approved proxy price that was the only acceptable price at which to pass through the cost of Unit 3 energy and capacity to customers. EPE has no CCN to use Unit 3 to serve EPE's New Mexico customers. Thus, EPE is not authorized to pass through the actual costs of using Unit 3 to serve New Mexico customers. During URI, EPE had authorization to use energy and capacity from Unit 3 to serve New Mexico customers only according to the terms of the specially approved stipulated agreement described in the RD. If EPE's decision to use Unit 3 to serve customers during URI was appropriate, then the cost must be passed through at the proxy price. Accordingly, that got to staff's exception, which I already discussed. So I'm skipping now. I'm skipping the next two paragraphs because they address staff's exception and their two recommendations, which I've already discussed. So I'm going down to where it says determining, the paragraph that starts with determining. Determining whether EPE appropriately used Unit 3 energy during URI requires answering two questions. The first question is whether the use was within the scope of the specially approved arrangement. The language of the operative stipulation, as approved in docket number 9-171 UT, states that, quote, EPE shall provide available energy from Unit 3 needed to serve EPE's New Mexico jurisdictional customers when it is operational and capable of delivering power to EPE's retail customers, end quote. That's quoting from the stipulation. EPE, that was approved. EPE's decision to use Unit 3 during URI falls within this broad authorization. That's what the proposed order would find. The second question that must be answered is well described by the city in its exceptions. Referring to the initial hearing examiner's procedural order, the city states that EPE must demonstrate that its voluntary choice to use Unit 3 during February 2021 at the proxy price reflected the lowest cost power available to EPE. The hearing examiner rejects the contention that the procedural order, sorry, I just went down too far. Rejects the contention that the procedural order establishes the applicable burden of proof, finding that the showing required by the procedural order is contrary to applicable law. However, in the event that the lowest cost energy available tests were applied, in other words, the hearing examiner actually did the analysis anyway. The hearing examiner found that the commission had determined in docket number 9171, where the stipulation in its current form was approved, that the proxy price for Unit 3 energy and capacity is, quote, is representative of the lowest available market price for firm capacity and related energy. And the proposed order had the commission concur on that. In other words, the language of the stipulation is very broad and empowering to EPE. I was surprised because I either hadn't reviewed it before or it had been a long time since I reviewed it. I expected to see a stipulation that allowed for the use of Unit 3 energy in particular circumstances and exigent circumstances or something like that, because it's not an approved, a generally approved resource. But it's as I quoted there from the stipulation, EPE is authorized to provide that energy from Unit 3 whenever the unit is operational and capable of delivering power. So it has a broad authorization to use it, just as if it did have a CCN. And two, I agree with the hearing examiner that oddly enough, the language of the stipulation essentially states that by using the proxy price that was arrived at and adopted in 2009, that it's a foregone conclusion. In other words, basically an unrebuttable presumption for attorneys out there that this resource, when used, is always the lowest available market price. That there's no analysis to be done. And I agree with the hearing examiner. The language of the stipulation really states that. And I found that bizarre because how could you determine the lowest cost alternative available without looking at the actual alternatives in the market at the time that the decision to use Unit 3 is made. How could that be decided from the, for all time, essentially in 2009 and for all time that this is used, Unit 3 is used, it shall be considered the lowest cost energy available. And then I agree with the hearing examiner. That's what the stipulation says. So that's why I recommend to the commission that the commission adopt the hearing examiner's RD. I think it's the correct analysis. With that, now I didn't address some issues concerning a procedural motion, but that procedural motion is moot, so I won't go into that. So I think I'll stop there. I know that Commissioner Fishman has an alternative recommendation, which he would like to discuss. And so I'll turn it over to him if he would like to speak now, or if Madam Chair, if you would like to ask for questions of me first, that's fine as well.
Yes, I might do that. Commissioners, does anyone have any questions at this point of Russell before we go to Steve's proposed alternative? Commissioner Vicente Aguilar, do you have any questions for Russell?
Madam Chair?
Yes. Yes,
Uh,
Commissioner
If
Fishman.
there are no questions, I'll just quick present my point that I discussed with Russell yesterday.
Yeah, I think that's fine. I believe I see her number, but she may be just listening. Okay, well, please proceed, Commissioner Fishman.
So first of all, I think Russell analyzed this perfectly, except for one small point. And that's where I'd like to discuss a little bit. We're relying on a 2009 stipulation that basically states a priori that this formula is the lowest price in the market. And Russell, pointed out quite well that, how can you do that if without looking at the actual prices that were in the market at the time? And but there it is in the stipulation. And my argument to Russell was is that I believe that stipulation overstepped. And it overstepped because it basically totally ran over the public policy concept that the utility has the obligation to use the least cost resources to fulfill the demand of its native customers. And I don't think that legally you have the power in a stipulation or any private agreement to basically ignore public policy. And I think Russell in his discussion made that point himself. So, I can't declare that dirty water is clean water in a stipulation where there's public policy that's clear about what clean water is. I can't declare that night is really day. I can't start creating definitions in a stipulation that basically ignore what public policy is. So I think it's a mistake to rely on that 2009 stipulation. It's not rule, it's not law, it's a stipulation. You can't use a private contract to overrule public policy and public law. And I think that's what's happening here. So I do think that the city has a valid exception. At Mary Lee Souls, they have a valid exception when they raise that point. So while I don't think it's debatable what the price is, I think it should have been examined whether El Paso Electric, seeing a favorable price, arbitrarily assigned more sales from that facility to native customers than they might have needed to in order to experience an excess profit. And that was never explored because the discovery on that issue never occurred. So my proposal would be to adopt Russell's order, but ask for just reopen the hearing to allow exploration and discovery on that one issue. Because I think that, quite frankly, those parties have been denied a fair hearing and due process on that issue. And I think it's important that we kind of adopt an approach, though this commission will obviously won't decide on it, but we need to adopt an approach that we err towards getting a complete record rather than making decisions that give an incomplete record that might not give us the full picture. And I think that's what's missing here. So I would ask for that amendment to Russell's order.
Commissioners, any discussion on Commissioner Fishman's proposal? Mr. Byrd? No? Mr. Maestas?
Do we have any language at all, or?
Well, not necessarily. I think he just stated his viewpoint.
Madam Chair, Commissioners, well, let me just clarify with Commissioner Fishman. First of all, I'd like to note that I had the same concern. This is where when I was speaking to Commissioner Fishman yesterday, I said this was a sticking point for me too. I do think that the hearing examiner is right. The stipulation sort of decided that issue, which is that proper when you have no idea what the circumstances will be in the future? I mean, least cost available necessarily is a process of looking at what's actually available at the time. So it is still marginally, in my opinion, I still recommend the proposed order just because that is a stipulation. But I agree with Commissioner Fishman. I've never seen a stipulation like this. I was kind of, as I said, shocked to see that it made such a decision. So first of all, I just want to comment on the substance of this. I think I understand Commissioner Fishman's
So, excuse me.
Proposal.
Yes, I'm glad you do. I want to get some responses from the other commissioners, and that is Commissioner Vicente Aguilar, if she had any thoughts on this proposal. And if not, yes, go ahead, Commissioner.
Madam Chair, can you hear me?
Yes.
Okay. Russell, can you explain to me when Commissioner Fishman stated that this is incomplete record? Can you explain whether that is accurate or not?
Yes, Commissioner Vicente Aguilar, this is what I would say. It goes directly to this issue. You can look at it one way, which is that because the stipulation says that the use of this unit 3 at the proxy price shall be considered, the least cost alternative, or similar language in the 2009 stipulation, that it's unnecessary to look at the actual alternatives that are available at the time of this crisis in February 2021. So my proposed order would go with that idea and say, that's what the stipulation says. But I agree with Commissioner Fishman that that language of the stipulation is I don't know. I don't know if I would say, I don't know, but I don't know how it would be treated by court. It's so unusual to make a factual determination about future conditions, indefinitely into the future, in a stipulation like that. I mean, it seems to agree that least cost alternative is the appropriate test, but says you will never have to look into this question. We're deciding right now that this proxy price will always be the least cost alternative. So I think the commission should simply apply stipulation, but that's a 51% for me. 49% of me says that's absurd. You have the only way to apply the least cost alternative standard is to look at the alternatives available at the time. So that's what we're dealing with. Commissioner Vicente Aguilar is that the language of stipulation would say, nope, you don't need this discovery. And my proposed order would say that as well and say the hearing examiner is right. That's the stipulation. But what Commissioner Fishman is saying is no stipulation should ever contain that. It would be contrary to public policy because you can't simply decide that in 2009, what is the least cost alternative in February 2021. And I don't know where the court would come down on that. I think it's quite possible they'd come down on Commissioner Fishman's position. But because I don't know, I'm saying just go with a stipulation. So does that make sense, Commissioner Vicente Aguilar?
Yes, thank you. Thank you, Russell.
Thank you, Commissioner Vicente Aguilar, and thank you, Russell. Well, I guess I'd like to provide my reaction, which is that I'm completely persuaded by Commissioner Fishman's argument based on the reasons he gave, which is that we have to look, commissioners, in order to pursue our duty and carry out our duty to protect the public interest and balance the interests of the parties fairly, can't be restricted to a decision that is based on a stipulated agreement in a particular case in the past that didn't contemplate the set of facts that we were looking at during the Storm Uri. It would be absurd, as Russell mentioned, and there's also a principle that I hasn't heard talked about except by me earlier, which is that generally the terms of a stipulated agreement only pertain to that case in which they're used. It is a contract, as Steve stated, and it's to solve the problem that is intended to solve in that particular case. They usually don't have precedential value unless it's written in that they should be applied in the future at a certain specific date. We do have one such instance where that has been applied that gave rise to closure of coal plants in the past. But in this instance, I haven't heard any argument that language was intended to operate that way. And even if it did, it would run counter to our basic obligation to balance interests in such a way as to protect shareholder versus ratepayers and the public interest. So to me, this is a very easy decision, really, to say we are not constrained by that language in the stipulated agreement, particularly under the circumstance in this case where there does seem to be a limitation on parties' abilities to at least investigate the intention and the facts surrounding the development of that language in the first place. So I do agree, and I think that was an impingement of due process there for that party, and I think the solution to have the record reopened to investigate that point is a very common sense and fair approach. So that's my opinion, and I think Commissioner Vicente Aguilar put her finger on it. What does it mean when Steve said there's an incomplete record? There may well be an incomplete record here. And the only way to fix it is to open the record. So that's my thoughts on this. Commissioner Maestas, I know you were asking about what is the language of the proposal, and I'm sure Commissioner Fishman would be glad to lay that out again. So unless I've stimulated any further discussion, I would like to hear a proposal. We should have some language so we can discuss the language. So.
Well, Madam Chair, I think it'd be good to check in if there are any other comments folks want to make, and then I'll throw out some language.
Right. Well, I thought I just did. I was asking for comments, but I called it discussion. So maybe that threw people off. Are there any other comments? Commissioner Beard? No? Commissioner Maestas? Commissioner Vicente Aguilar, do you have any further comments?
No, thank you.
Okay, thank you. Okay, no further comments. Steve, would you like to?
Well, so I would adopt Russell's order as to all of the findings, except as to the issue of whether the appropriate amount of power from Palo Verde was charged to EPE customers. So Russell, I'm going to ask for a little bit of help from you here. And it seems to me all we want to do is just open the record on that one issue and simply determine whether there were any appropriate charges as a result of over allocating Palo Verde to EPE native customers.
Commissioner Fishman, yes, I think I have come up with something. So first of all, this order would, as per Commissioner Fishman's proposal, would adopt all the findings of the RD, except as to this question. And this is how I would put it, because this order would have to include an assignment to another hearing examiner to conduct this proceeding. Even though it'll be limited in scope, I'll have to go to another hearing examiner. It will not be able to go to Robert J. Lennon. He will be enjoying a richly deserved retirement. December 31st is his last day with the commission, as you may all be aware. I'm not sure if everyone is aware of that, but he did announce that. So congratulations, Bob, on that. So this would be an order that would assign the matter to a hearing examiner, which we can to be named in a separate single signature order. So I can discuss that with Anthony, who should be assigned, and with the specific instruction, this instruction as to the scope. And I'm typing this out so that I will have it exactly. So the order would adopt the RD, except as to the question of whether, that's how I'll put it, adopt the RD, adopt all findings and conclusions of the RD, except for the conclusion based upon the language of the stipulation that EPE's use of Palo Verde Unit 3 energy and capacity during URI reflected the lowest cost alternative available to EPE. And then that'll be in the findings. And then the ordering paragraphs would include assigning the matter to hearing examiner sorry, just typing. Assigning the matter to a hearing examiner to be named in a separate single signature order let's see, sorry, single signature order for further proceedings limited to the question of whether PV3 energy at the proxy price, energy and capacity, excuse me, at the proxy price what reflected the lowest, I'll say was the lowest cost alternative available to EPE. And I'll say specifically, this inquiry necessarily involves allowing discovery of and inquiry into the alternatives that were actually available to EPE during, I'll say, in February 2021, because I think the price issues continued after, the week or 10 days of URI, but they were all within February 2020. So I'll reread that. So in the findings and conclusions, instead of adopting all findings and conclusions of the RD, it would say the commission adopts all findings and conclusions of the RD, except for the conclusion based upon the language of the stipulation that EPE's use of Palo Verde Unit 3 energy and capacity during URI reflected the lowest cost alternative available to EPE. And then the ordering paragraphs would assign the matter to a hearing examiner to be named in a separate single signature order for further proceedings limited to the question of whether Palo Verde 3 energy and capacity at the proxy price was the lowest cost alternative available to EPE. This inquiry necessarily involves allowing discovery of and inquiry into the alternatives that were actually available in February 2021. How's that sound?
I like it.
And I may have to make some
Russell?
other little tweaks to language, Drake, here and there to make it consistent with that. But otherwise, that would be the heart of it.
Okay, so Commissioner Fishman, is that your motion?
So my motion would be to approve the order as amended.
All right, I've got a motion, folks. Do I have a second? I'll second it. We have a motion and a second. Any further discussion? Hearing none. Mike, can you take the roll?
Commissioner Maestas,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Byrd,
Aye.
Commissioner Fishman,
Aye.
I don't know if there's extra points for more ayes, but Commissioner Hall,
Aye.
the motion passes 5-0.
Okay, thank you very much.
Madam Chair,
Yes, Commissioner Fishman.
just a quick comment. Russell did a terrific job of
Oh, yeah.
outlining the issues in this case. And even though we disagreed on a judgment call that he was very close for Russell, I just wanted to thank him for the terrific work in just putting the issues out there so clearly that we could even have this discussion in collaboration to come to this decision.
Thank you, Commissioner. I appreciate that. I think the parties did a very good job of developing the issues as well. That helped a lot.
Thank you very much, Commissioner Fishman, and I totally concur about Russell. He's sort of a tour de force. When I can get him to slow down, I really like it because he's so well spoken.
Thank you, Madam Chair. I appreciate that as well, and I will slow down my speech.
Liar. 4 years and you haven't done it. Why should we believe you now?
You shouldn't believe me. You should not. How about just for the next matter, Rosa Joint Venture?
Okay.
Well, yeah, he could show us up on the next matter. And prior to that matter, I would again like to take another 5-minute break now. So if folks don't mind, because you never know how long we'll go. So it's 12:28 right now. We'll come back at, well, no, it's 12:29. We'll come back at 12:35. Okay.
I've almost put it in the fire. And pass it back. Well. Which is fine, but let me get past Carney's Corners where they can get after. I was watching you on video, it's funny, you open that thing up and go. Well, what was in it, but neither did you.
It's a brand new container.
Oh, okay. See if it still have the oils in it.
Who gave us these anyway, do you know?
I think staff is what I heard. Santa Claus.
Oh, Commissioner Bird,
What?
how do you like it?
What did I do?
I have to apologize.
For what?
I ate your cookies
Oh.
in the last meeting. I might have left the rest of the bag, but I meant to bring you more cookies and I forgot. But you can have some of this.
I brought that.
It's delicious. Did you like it?
I don't need it. No. I bought it here in town yesterday.
Oh, it's wonderful. Sure, it hits a spot.
Bought it without intending to eat it.
I had a piece.
It must be after.
Oh, you're not on mute.
No, I just opened it up. It was 12:35, now it's 12:36. I think we can get started again. Let's see, so now we're on item number 5 in the regular action items, and that is case number 18-00214 UT. In the matter of an order to show cause as to why Rosa Joint Ventures LLC should not be found in violation of the Public Utility Act and Commission rules. Russell Fisk will present a potential order regarding staff's response to the Commission's November 30th, 2022 bench request and a potential order regarding next actions. So Russell, once again, you have the floor.
Thank you, Madam Chair and Commissioners. Before I proceed to Rosa Joint Venture, I do want to take a detour back to the previous case. This will not require a vote of the Commission, but the language that I read aloud for the motion for the proposed order language use the term least cost alternative, which I think is a term that was used in the past, may even have been used in that matter. But Michael rightfully pointed out to me that the proper formulation of that is most cost-effective resource. That simply reflects that the most cost-effective resource may or may not be the lowest, strictly the lowest cost alternative available. I don't believe that requires the Commission to revisit the vote. I just wanted to let the Commission know that I'll be using that more proper term instead of lowest cost available. So I can take any questions if anyone has any questions for me, Madam Chair.
Commissioners, do you have any questions of Michael and of Russell in using that correction that Michael provided? Hearing none, I think we're fine with that, Russell. Thank you very much.
Okay, thank you, Madam Chair. So with regard to Rosa Joint Venture, the most recent order that was issued by the Commission was issued on November 30th. That was an order denying Rosa Joint Venture's motion for reformation of the transfer agreement on the basis that the Commission does not have the power to equitably reform a contract. The Commission simply has the power to approve or disapprove certain types of contracts, such as this particular transfer agreement, which the commission did approve over 2 years ago. But that order, the November 30th order, also included a bench request order to staff. And that included a number of questions, and I'm actually just going to read them. Staff was asked to provide recommendations regarding any options that may be available to the commission to invoke any powers that the Office of the State Engineer may have to compel a transfer of the necessary water rights to Sambrito, that's the mutual domestic that was formed, or otherwise to accomplish the water rights transfer as soon as possible. For example, by commencing an action to revoke the rights and to reissue them to Sambrito, which was a speculation as to what might be possible that staff should look into. So that's number one. The bench request also asked staff to inquire as to the status of any Rosa joint venture partnership dispute or dissolution proceeding pending or concluded in any court. This was because there was actually such a proceeding referenced in filings around the time of the November 30th order. The third instruction to staff was to determine whether the commission has standing to intervene in any such pending proceeding. The fourth instruction was that if the commission has such standing, the staff was to make recommendations to the commission as to whether the commission should intervene in any such pending proceeding and as to what actions the commission should take in any such pending proceeding. And the fifth instruction was to provide recommendations as to how to address staff's current understaffing in the area of water / wastewater utilities, including whether the commission should hire a contract staff member whom the commission might consider for such a contract and for what period of time. On December 12th, staff filed a very complete and timely response. First of all, staff addresses the powers of the Office of the State Engineer. Staff cites the New Mexico Constitution's beneficial use doctrine regarding water rights. Quote, this is quoting from the Constitution, beneficial use shall be the basis, the measure, and the limit of the right to the use of water, end quote. Staff further quotes the state's statute providing for forfeiture of groundwater rights when such rights are not used beneficially as directed. And I'm going to go ahead and read the language from the statute because it's important. When for a period of 4 years, the owner of a water right or the holder of a permit from the state engineer to appropriate any such waters has failed to apply them to the use for which the permit was granted or the right has vested, was appropriated or has been adjudicated, the water rights shall be, if the failure to beneficially use the water persists 1 year after notice and declaration of non-use given by the state engineer, forfeited, and the water so unused shall revert to the public and be subject to further appropriation. It's not a wonderfully written statute. There are a lot of nested clauses there, but the idea is when a 4-year period has passed where water rights have not been used for the use specified by the Office of the State Engineer or by a court, then they may be forfeited, but only after an action is filed, or I guess it doesn't have to be filed, but the state engineer has noticed this, has found that a period of 4 years has passed, like that, as described, and provided notice to the obviously to the user or and a declaration of non-use. Then there's still a period of a year after that notice in which the holder of the water right can essentially fix the issue and start using the water for the proper purpose. That's an important point for my proposed order. Staff states that throughout this proceeding, Rosa Joint Ventures marked failure to properly utilize, conserve, and efficiently direct water resources in the provision of water utility services has been apparent. Staff suggests that the commission and or other parties aggrieved by Rosa Joint Ventures' pattern of conduct and practices could explore the possibility of triggering an action for forfeiture of water rights with the Office of the State Engineer simultaneously while the outstanding transfers at issue in this proceeding are pursued to completion and satisfactory conclusion. So I'm going to address how the proposed order would address this recommendation first before moving on, because it's separate really from the other recommendations. So I'm going down now in the memo to the last paragraph of the memo. As for pursuing action by the Office of State Engineer, the proposed order would state that the commission disagrees with staff that the groundwater right forfeiture statute is likely to provide an avenue for achieving a quick resolution of the current situation. First, though there has been waste of water due to the leaky system, it is not clear that any water rights have been misappropriated to unauthorized uses by RJV, Rosa Joint Venture, or its partners. Second, even if there has been such misappropriation, the statute provides for a period of 1 year of notice before a forfeiture would take place. Thus, the statute would not provide timely relief. And we could discuss, Madam Chair, we could discuss that now, or I could go through the rest of them and then discuss them at the end. I'm planning to just go through the rest of them now. Madam Chair, is that sufficient?
Is your discussion of that point sufficient?
No, Madam Chair, what I was saying was, does the commission want to ask questions or comment specifically upon that, or should I go through the other issues and then at the end you'll ask for comment and questions? Since I kind of pulled that issue out and discussed it, but I can go forward. I was planning to just go forward with the other issues and then at the end discuss whatever the commission wants to discuss.
Well, I mean, I can ask the other commissioners. Commissioners, do you have any questions on this particular issue at this particular time? Because we can discuss it after Russell covers all the other issues. But if you have questions on this particularly, this business about possibly going, the commission going before the Office of State Engineer to possibly require Rosa Joint Ventures to relinquish their water rights because they're not using them for the purpose water rights are afforded to owners. Anybody want to have a comment on that? Mr. Byrd? No. Mr. Miosis, Commissioner Vicente Aguilar, any comments on that point?
No comment.
Okay, Commissioner Fishman?
No.
Okay. I personally thought it was kind of a creative argument, but I'm not sure it would, but I know you raised points against it as well, Russell, and we don't need to go on that right now. Let's see what else you want to say. And then
yes, thank you, Madam Chair.
Yeah.
So staff next addressed in its response the commission's inquiry regarding any partnership dispute or dissolution proceedings. Staff states that the only pending partnership dispute or dissolution proceeding of which staff is aware is, and there's a particular case number, in Colorado's 6th District Court in La Plata County. I'm curious as to why it's in Colorado. I'll get to that in a minute. Staff does not state whether the pending matter is a partnership dispute proceeding, a partnership dissolution proceeding, or a creditor's action against the partnership. Staff notes that a status conference is currently scheduled in the proceeding for January 17th of next year. Staff states that it would appear that the commission is an ostensible creditor of Rosa Joint Venture, such that the commission should have standing to, at the very least, present and or ensure that its creditor's claim is recognized by the court in Colorado and otherwise protected in conformance with New Mexico law. Staff recommends that if the commission is inclined to involve itself in the Colorado proceeding, consultation with qualified counsel admitted to the Colorado bar is advisable. And the proposed order would have the commission find that it should intervene in the pending court proceeding in Colorado's 6th District Court to pursue collection of the monetary penalties that have accrued against Rosa Joint Venture and to ensure that the interests of Rosa Joint Venture's ratepayers are protected. I looked into what information was available online regarding this particular matter because staff didn't seem to know very much. And I found out why, because Colorado does not provide very much information. It doesn't provide access to actual documents that have been filed in the case online. It doesn't even provide a docket that lists what's been filed in the case. So I don't know what kind of action it is either, but it does involve Rosa Joint Venture, and it does involve some of the Phelpses. The two Phelps brothers are, I believe, the partners in Rosa Joint Venture. So it certainly is a relevant case. So I can find more information about that somehow. Might have to do it the old-fashioned way, which because as I said, the website of the of Colorado courts is not very helpful. But I think that we should seek intervention. This is something that I've done before on behalf of the commission in AV Water's receivership with regard to its larger of the two water systems that it once operated, the Morningstar water system. That went into, there's a receivership proceeding that was not brought by the commission, but by creditors. And the receivership was handled very well. And it was eventually sold, that particular system was eventually sold to New Mexico Water, New Mexico Water Service Company. So that went very well. But we did intervene, the commission intervened in that receivership proceeding to represent the interests of the ratepayers and make sure that the Public Utility Act was honored, which it was in that case. And so I don't see any reason why the commission wouldn't be able to intervene in this proceeding as well. So I will look into that as soon as possible. I'll move on to the next issue. Let's see. Next issue is that staff responded to concerned, let's see, the commission's inquiry regarding the current staffing level within utility division regarding water and wastewater utility regulation. There's good news here. Staff states that it has been working on the understaffing issue. Staff states that in October, Richard L. Martinez, PE, I believe it means, does it mean public engineer? I believe it does, was hired as the engineering bureau chief for the utility division. And that Mr. Martinez is a subject matter expert in civil engineering and engineering mechanics, urban and regional planning, and watershed management and natural resources. Staff adds that Mr. Martinez has initiated and completed the planning, design, procurement, demolition, construction, testing, commissioning, and turnover of small and very large project deliverables, including water distribution and sanitary sewer collection and treatment systems. And also that Mr. Martinez served as a senior project manager with the City of Tucson's water department. So we're very lucky to have Mr. Martinez, who is very experienced in these areas. So that's a big point on our staffing, because as you recall, Tim Martinez, who is the commission's or was the commission's only water engineer, I believe remains on medical leave. Staff further states that its engineering bureau is in the process of filling an engineer intern position. Staff further states that it is also in the final stage of entering into an open-ended contract with a New Mexico water and wastewater infrastructure consultant as an independent third-party reviewer. Staff's response is supported by the verifying affirmation of Ed Rolkoff, our somewhat new utility division director, who we were also very happy to have, and the verifying affirmation of Richard L. Martinez himself, the engineering bureau chief. I just want to say again, we're very happy to have someone with so much experience in water because we need it. So with that, I think I've covered everything in the response. Just to summarize, the commission and the proposed order of the commission would reject staff's recommendation regarding pursuing an action for forfeiture of groundwater rights by Rosa Joint Venture or its partners, as would be untimely and may not be really the appropriate solution, might not apply, but would have the commission find that it should intervene in the pending court proceeding in Colorado, the partnership dispute. And the proposed order doesn't say anything about staffing. It just sounds like, to me, it sounds like good news. Really made progress and are continuing to make progress in staffing up for water, wastewater issues. And with that, I will take any questions.
Commissioners, any questions for Russell on any of the points he brought up? Mr. Fishman, any questions? No?
Well, I just want to move the order.
Okay, and Commissioner Vicente Aguilar, any questions?
No questions.
Okay, Commissioner Bird.
I'll second the order.
Okay, we've got a motion and a second. Any further discussion? Hearing none, Mike, can you take the roll?
Mr. Hall.
Aye.
Mr. Bird.
Aye.
Mr. Maestas.
Aye.
Vicente Aguilar.
Aye.
And Commissioner Fisher.
Aye.
Motion is by a vote of 5-0.
Thank you, Mike. Okay, now we'll move on to item number 11, Roman numeral 11, communications with Chief of Staff. This will be our last communications with our fine Chief of Staff.
Well, Madam Chair, we made it.
We did, didn't we?
Good afternoon, Madam Chair, members of the commission. It is an honor to be here, actually, on this last meeting for the current commission and the current elected iteration of the commission. It has been an honor for me to serve in the Chief of Staff role for a brief period of time, but I've served long enough to see the work that you have done, the work that the staff here has done. I read your and the vice chair's op-ed a week or so ago in the Journal and the Santa Fe, New Mexican, and I was just reminded of the really remarkable accomplishments you've had and that you have a lot to be proud of. This is an extraordinarily important state agency. I thought I knew that before I came here, but I'm not sure I really realized the breadth and scope of the work that this commission does and the work that the staff does and how it really truly does. We talk about this, Madam Chair, but I'm not sure if we sometimes really stop and mean it, but it really is true that what you do affects virtually every part, every person, every citizen of this state, every aspect of our economy and the future of the state. And the future of this state is in much better shape because of your service as public servants. I'd be remiss, Madam Chair, not to specifically thank the Vice Chair, Commissioner Maestas. I think it was his idea to bring me here. Be forever grateful for that. Joe, thank you. Thank you. Won't forget it. Thank you. But to all of the commissioners for your support of me as Chief of Staff, I was welcomed by you, supported by you. There's work still to be done, and I'm a little disappointed by some work that didn't get done, but that's okay. Others will come along and continue the good work that you have done and that staff has done. This commission's in good hands. I can't say enough about the staff here. I know I don't need to tell you that, but you know, when I walked in here, I wasn't quite sure what I would find, but I can tell you I found as dedicated and talented group of staff at the PRC as any that I've ever worked with in almost 20 years in state government. So the new commission is in good shape, in good hands. It'll be tough, I feel, for Mike and the staff with the transition already underway with the new commission and now having to undergo a transition for a new chief of staff, but they've survived worse, and they'll continue to do the superb work that they've always done. And so, Madam Chair, I just want to say thank you. Best wishes. Made some friends here. Those friendships will continue. And in my new role, certainly, the door is always open. So thank you, Madam Chair.
Oh, thank you very much, Mr. Probst. It's true, we all worked really hard, but I don't know that we would have been successful without you here. You really did wonderful things in terms of getting hirings made and just smoothing out processes of all sorts, and getting the administrative services and financial section of our agency really staffed up and running on all cylinders. And it's been a real pleasure to work with you. So I would like to hear from my fellow commissioners what they think, but it's just been such a pleasure to work at the commission with a quality chief of staff like you, who can inspire the staff. And I think you did. So commissioners, anybody have any rejoinders to commissioner, to chief of staff?
Thanks, Madam Chair. Well, time has flown by, Wayne. But I too want to acknowledge, I think, the impact that you've made immediately on this organization. We all aspired to stabilize and professionalize the agency, and you came in here and did just that. And well, obviously, I'm not the only one that recognized that. I think the governor duly recognized your great potential and your reputation for professionalism and being an effective state executive. There aren't too many folks in your realm that have that kind of experience that can head a cabinet department. And you know, we are a small state, but I have no doubt that you will take Department of Finance and Administration to new heights. It is a significant agency, and I know you're up for it. I'm a little maybe sentimental in that you're leaving, as am I, as we all are. But I did want to just state that when you first got here, you made it a point to shadow your employees out in the field. And I think that, you know, from a leadership standpoint, from the standpoint of getting to know your staff and their jobs, stuff like that's really critical. And to me, it didn't go unnoticed. And I know you'll continue exercising that type of leadership, which I think is extremely important, especially in this environment that we're dealing with post-pandemic. Employees now have a whole new we're just going to all have to adapt to this. And I mean, there'll be some challenges ahead, but I just wish you happy trails, Wayne. And I'm sure our paths will cross, hopefully in a positive manner. But it's been an honor serving with you, Wayne. And this agency was fortunate to have you for as long as it did. And I just wish you the best. Thank you.
Mr. Burton, any comments?
I'll pile on. So yeah, you know, part of having a successful sailing ship is to have a adequately commissioned ship. And what you have just stated, and what I will acknowledge, is that the staff and the commission body itself has had the desire to make this agency work right. You know, and there's an adage that I always had in my office when I had an office. That it's hard to soar like an eagle when you're working with turkeys. And and that's true. But at this office, at this agency, there's a lot of good people here. And you had the wherewithal to make it run smoothly. And that takes ability that you had, that you brought in, and you admitted yourself that you really didn't know what we were doing, but you would make it work. And you have done an exceptional job at that because you had the ability. And that was reason I supported your hire, is because there was clear ability there. It didn't matter that you didn't know the ins and outs, because I knew staff knew how to do it. You just need to make sure that it ran smoothly and worked, and this engine worked together. And I think you have fell in place and done a great job. And because of that ability, you will do well in the future. But I want to commend the commission itself, because if your ship was always being topsy-turvy and in rough waters, it's hard to make it look good. But this commission, the body, my colleagues, have, I think, exemplified how an elected body should work. And anyway, congratulations on your nomination, and we will all move forward, and this commission will be in good hands, as you said. Thank you, Madam Chair.
Oh, thank you, Commissioner Byrd. Commissioner Vicente Aguilar, would you like to make any comments to Wayne?
Thank you, Madam Chair. Yes, I would like to make comments in regards to our Chief of Staff, Wayne Probst. When he first came on board, he told a reporter that he's only going to focus on the duties. And that's what he displayed, and he was successful. One thing that I've learned from Wayne Probst is that he will watch, he will observe. He doesn't have a lot of words to say. When he's not in a hurry to express his opinion. Instead, he's standing back, watching all the staff members, taking care of the commissioners, taking care of the general counsel's office. He knew how the wheels were turning, and he did it well. He did it very well. And I am very happy that we have come to this time that we are going to meet at our last meeting. I'm very proud. I'm very proud of my colleagues. We focus on the work. Every once in a while, things got a little bit off the wheel, but we focus on the work. We continue to put our staff members at the front lines. Let's not forget about the employees with the pipeline safety. Let's not forget about them. They're the ones that were out in the district contacting health hazard, but they managed to get through. And I'm very proud, Madam Chair, and I'm very proud with how our Chief of Staff pulled the wagon to the very end, and he did it very well. Thank you. That's all I have to say.
Thank you, Commissioner Vicente Aguilar. Commissioner Fishman, any comments?
Wayne, what an ideal employee. Just a manager's dream, although I'm not a manager. None of us are in the commission, but It's just a matter of cutting you loose and being smart enough to listen to your good advice. And you've got a steady hand. You didn't rush into anything, but still picked up on where we are and what needed to be done very quickly. And I know you're going to be a tremendous asset over at DFA. And I know that however harried and busy it was here, with all that money floating around and all those greedy little hands trying to grab some of it, you're going to have faced quite a challenge in trying to be sure we make the most of our sudden glut of resources. And I know you're the guy who can handle it. And I know great things are going to happen wherever you go. So congratulations. We'll miss you. And good luck.
Thank you, Wayne, for everything. Okay, commissioners, now we have item Roman numeral 12, communications with general counsel. How do you follow all that, huh?
I was gonna say, you all know me, I am not given the florid speech and sentimentality and on behalf of all the turkeys who are staying here. I'm not even sure I represent to speak for them, but I do want to thank the commissioners who are going out for their civility and for me, one of the things I value, your sense of humor and good nature in doing your jobs, which I think goes a long way to maintaining the morale in the agency. To have a group of commissioners that are approachable and are good people to work with. And
but what about our brains and good looks?
Good people to work with. And I thank you for that, because I think it's valuable for all the employees to be able to relate to the commissioners, and as I said, find you approachable and be able to discuss things with you. So I wish all of you the best from our my little group at OGC. I know we all feel the same way. And good luck in your future endeavors.
Thank you, Mike. Commissioners, any comments of appreciation to Mike? Even though he's not going anywhere.
Make it short.
All right.
Appreciate you, Mike.
Thanks.
No, I'm going to make just a general thought is that I hate the law. I hate the legal system. And Judy, I used to joke with her about it. And even my assistants who were attorneys, and Robert, is that some of the fine distinctions that get drawn, and they just drive me nuts. And I just kind of want to get down to common sense. And I know that must at times make me a pain to deal with for general counsel in particular. But I want to say that over time, I feel like working with general counsel and not just you, Mike, but the whole office, and of course you set the tone there. It really turned into a collaboration, and I felt very comfortable with the back and forth, and I think it made me a lot better at what I do, and I really appreciated general counsel's willingness to listen from my kind of non-legal, impatient point of view. But it really was a pleasure working with you all, and I just felt like it was a true collaboration, and I felt like everybody was there for the right reason, trying to do the right things. And that just created a lot of confidence in doing. And so I just wanted to thank you for that. And thank you, Mike, for setting the tone for that entire part of the agency. Because I do think your leadership has a lot to do with it. So thank you.
Commissioner Vicente Aguilar, do you have any kind words for Mike?
Thank you, Madam Chair. Yes, I think General Counsel's office, I think they have handled our needs very in an exceptional way. I remember when I traveled to a conference in Hawaii, I had to log on. I had to dial in 5 o'clock in the morning. And the first topic on the agenda was losing Isaac. And I was in tears. Many of the staff members were in tears. But we got over it. Here we are. We have flourished. We climbed and climbed, and we reached out to more exceptional employees, more exceptional staff members, and here we are. We have finished, and General Counsel's office was part of it. They were part of the puzzle. They kept it all together. They clustered all the cases together. They said, this is not the right way to do it. This is the best thing that we can do, and put it on the record. This is how we can also work together to regroup and to come up with an amended vote, whatever it was. General Counsel was there to complete the puzzle. That's my quote, Madam Chair. Thank you.
Thank you, Commissioner Vicente Aguilar. I forget, did I ask you already? Do you have any questions? And you? Okay, well, then it's my turn. Well, all I can say is it's been a real pleasure to work with you, Mike. I remember when you started, I think I might have still been in General Counsel's office then. I'm not sure. Oh, maybe I was in Insurance Division, right?
You had actually just run for, actually you were running for office.
Oh, okay. Well, in any case, that seems like a long time ago. But in any case, I've always appreciated the way you worked. You must have just been an attorney at first, but as a General Counsel, that's the main way I recall you. Even-tempered, low-key, enabling of your employees, creative in your thinking, and very deep in your analysis. I could always rely on you to take a long time to write thoroughly about what the solutions are. Not a long time, but often you would write rather lengthy opinions, and they were all necessary. Everything was necessary. All the pieces fit together. I think you've been one of the most professional attorneys I've ever seen, and I'm really glad that you're not leaving the commission, and that you'll be there to helm General Counsel's office. You've done an excellent job. All of General Counsel attorneys, I think, are excellent. Between General Counsel's office, hearing examiners, which are all, when one leaves, another great one pops up, and staff. This is agency, I think, is really enjoying a renaissance, and I'm sad to leave it at this time, but on the other hand, I'm like Commissioner Vicente Aguilar. I'm really, really proud of everything we've accomplished and the way we've gone about it. This is this place really does feel like family. I mean, or else just a group of some of my best friends. And I think that's not something I've been able to say about workplaces in general, but certainly it stems a lot from general counsel's office. I think because we commissioners deal with general counsel's office so much. So I want to thank you not only for being as professional as you are, but inspiring that and people who work in general counsel's office and encouraging their quality work and communication. So thank you very much, Mike. Carry on the good work. So, all right. So any comments back, Mike?
I wish I had the mic for everybody else in general counsel to respond, because I think, as you pointed out, and I should have emphasized more, it's really, the group, it's our group in general counsel that we work together, and they should all be up here right now. But it's also, as you said, the entire agency. And I'm sure everybody is, is sad to see this group of commissioners departing.
Yeah.
And I'll just add, when you first came on and I had my orientation with you, I pointed out to you what I point out to other commissioners, and I say, the thing I have to do in my job is I have to tell you guys when you're wrong and what not to do. And so I have to say no to the commissioners.
Yeah.
And I will say that this group of commissioners, I have had to do that less to than I have had in the past. Not that I haven't had to every once in a while, but we have to keep on each other's. So thank you for that.
All right. Thank you for that too. Okay, so we're down to the very end, communication among commissioners. Commissioners, comments?
I love you guys.
I love
This
you.
is, I've never worked with a group who I was so certain that they really had the public interest at heart. Yeah, whether we agreed or disagreed, I've never had such total confidence that people were here for the right reason. I think it allowed us to work together quite well and agree on a hell of a lot more things than we disagreed on. And so it's been terrific working with you all. And I have a strong feeling of accomplishment from working with this commission. And I just want to thank all of you for making that possible.
Thank you, Commissioner Fishman. Commissioner, yes, Commissioner Knight.
Wow, I never thought, I've kind of imagined that this moment would be here, but now that it's here, it's bringing up a lot of mixed emotions about my tenure, on this agency, with this agency. And it's been the best job I ever had. I mean, by far. I was the only newbie a couple of years ago, and I think OGC, you guys were really good with me, helping me learn the processes and kind of learning the ropes. And it's been quite a journey. And I'm really proud of all the work that we've done. Well, so much so I felt it was important that the chair and I let the public out there know, what we've been up to. But and we've worked with so many people over such a short period of time, climate action fellows, contractors, staff. And so, it is a team effort. It's a small agency. My only message is really to the state legislature that really, I think it's time to take a close look at many of these state agencies that are tasked with implementing and regulating very important laws. And I really feel like kind of enforcement implementation is not a priority. And so my hope is that this agency will receive the adequate resources that it needs. And I think you all know what I'm talking about. I mean, it really does need more technical expertise, more budget. But it's a great agency. And, you know, if it was up to me, I would have been perfectly content serving out a full 4 years. But, you know, that's not the way this happened. Just like any office, we're all temporary occupants, right? And so we have to try and do the best that we can with the resources that we have and the time that we have. And so I felt we've done this. I'm really proud of all my colleagues on this commission, more so over the collegiality and the involvement of every single member in a discussion or a particular action. I think that's what the people of New Mexico expect. And I really feel that we delivered that. So as I move on and turn the page in the chapter of my long public service career, I just want to say to all the staff, it's been an honor. Thank you for everything you do to all the people of New Mexico. And I want to extend a warm invitation to all of you to attend my swearing in ceremony on January 1st at 3 p.m. It's going to be at the Santa Fe Community Convention Center, and there'll be a reception soon after that. So it'd be great to see you all again. And I intend to continue serving the public at least for the next 4 years. So I'll see you all later. Thank you. Thank you, Madam Chair.
Thank you, Commissioner Maestas. Richard Woodward.
Thank you, Madam Chair. I'll try to be short. So anyway, I reserve comment for Mike because I just want to talk about staff in general. I think the staff here is exceptional. And I've been sitting here just running through people that I was going to mention. I decided that's way too many because there's always one I'll forget that I should have mentioned. But there's a lot of staff here that I'll walk away as friends now instead of colleagues, but that's okay. When you leave any place of business, you hope you walk away with more friends than enemies. And I think that once again, at least in my book, I don't care what you guys think. I'm walking away with more friends than I have enemies. And so I think this is a great group. Anytime there's change coming, everybody's a little bit worried about what that's going to look like. But the reality is it's always the same. It's just the politics are going to change a little bit. But this agency is going to continue to be strong because of the staff that works here. The commissioners, they can get in the way once in a while and make changes. And if it happens to you personally, it's tragedy. But the reality is this agency is strong. The staff here is very well prepared for this change. And the new commissioners would be wise to just let it ride for a while and learn. There's going to be, hopefully, there's some commissioners that will have intimate familiar with what we do here. But there's some on that list that, anyway, I won't get into the politics. So anyway, I wish the staff well. Change isn't always for the worse. You just got to roll with the punches and be ready for change, and it'll be okay. And so I wish you all well. I wish my colleague Joe well at his endeavor.
Thank you.
Do our state well as you have done here. I think you're going to be great. You have the mindset to be auditor. I think that's going to be awesome. And to the rest of my colleagues, wherever you end up, I agree with Commissioner Fishman. I have said that people have asked me about you. Why is he there? And I have always defended you in that. I've always defended you that your heart is in the right place. You want to do what's right for the people of New Mexico. And so
I never defended him.
And but with all my colleagues, that's why you're here. You want to do what's right. But for him specifically in response to his statement. But that's what makes it fun. You know, I like to have fun when I'm working. And so some of you have had to rib fairly hard to get a smile out of. Commissioner Maestas took him a while to break free and decide that it's okay to laugh a little bit when you're at work. Commissioner Fishman fell right in and started pushing back, and so it started. At that time, we were the bookends. He was on the other side of the bench, and so it was fun to push back and forth. But anyway, I wish you all well. I'm not, you know, I just go back to doing what I was doing when I looked for this job, right? I was looking for a job when I took this one. It's no big deal. So, so anyway, I'll be on the east side of the state enjoying my life on the ranch, and who knows what the future holds. Thank you, Madam Chair.
Thank you, Commissioner Byrd. Commissioner Vicente Aguilar, do you have any comments?
Yes, thank you, Madam Chair. I will start with Commissioner Fishman. He and we took the oath the same day, the same time, the same location 4 years ago. And one of the things that he said was to the judge that was going to preside over the oath, I want to see the piece of paper. I want to make sure it has my name on it. So he was already looking for, you know, the proper record. So that was, you know, really, you know, I just wanted to remind him what he did on that very first day. Commissioner Vice Chair Maestas, I learned about him in the 1990s. And I don't know if he remembers, but we were at a Democratic Party, and he was sitting on the bleachers, and just along with many other politicians. And it was at a high school on Indian School Road in Albuquerque. So, and that's when I met him, and we have worked in the democratic process, and here we are serving on the commission. And we've learned a lot from one another, more so serving on the commission. And Commissioner Hall, when I was elected in 2010, you were sitting in the general counsel's office as one of the attorneys, and I was already shaking hands, telling everybody, going from office to office, that I will be your next commissioner. And that's what I like to do. I wanted to make contact with the staff members, and that's what I did. I remember we chatted a little bit and we shook hands, and that's when I got to know you, Commissioner Hall. And then Commissioner Byrd, I wish that we could have served a little bit longer on the commission, because we represent an area that is rural New Mexico. And I just got an email from Department of Broadband Office, the newly created broadband office, and they want to hear about our ideas. Who is underserved? Is it true, the information, the record that's being revealed from the FCC? We need your feedback. And it was sent to all the state employees and all the state agencies. And I think they realized that PRC commissioners were the first to know how people are being underserved in rural New Mexico. So I think, Commissioner Byrd, I think you will have that opportunity again to serve the public and speak for the firefighters, the volunteers, and so on. So those are my comments, Madam Chair. Thank you very much.
Thank you very much, Commissioner Vicente Aguilar. I'll just wrap up with my comments and I won't go on, as I know I do sometimes. I just want to say, this is just, like Commissioner Myers just said, this is probably the best job I've ever had. It's been so gratifying to have the opportunity to serve the public. I didn't realize how gratifying it would be to wake up every day and get to work on trying to make life better for New Mexicans and our environment. And I'll miss it. But I have every confidence that the next commission will do a great job. When you look at the candidates, they all could be a good commission. Each one could be a good commissioner. And I have no doubt that even though it might be, a shock to some who haven't had any experience here, I believe that this commission will continue to operate very well, in no large part because of the quality of the staff, including the general counsel's office with whom they'll have most contact. And I'd like to think maybe by some of the example we've been able to set in this past 2 years. This has been absolutely the most collegial commission I've ever seen, and I've seen a number of commissions. And I think that carries the day. That allows us all to focus on our work and push ourselves farther, because we have goodwill among everyone here. And, that's kind of hard to achieve in any workplace. And I've been in lots of workplaces. And, I just have felt really privileged to work in such a harmonious, productive, and focused place for the past couple of years. I'm grateful. That's all I can say. I guess I'm grateful. I've had this experience, and I, like Steve, love you all. I really do. I have nothing but warm heart feelings for everyone here. And I'm sure we'll stay friends. And I'll probably invite you all to a party and pretty soon, because I'll miss you. And we don't have any more work to do together, and that I regret that. But as Commissioner Byrd says, change is unavoidable, and we have to look at it optimistically. So that's what I'm doing. And it's been an honor and a privilege. And I don't want to leave out here. I'm sitting here looking at Mark Fenton. Many of the people, everybody I've been in contact among the regulated entities has been also very pleasant, cooperative, helpful, and smart too. That's one thing I'll miss too, working with all these smart people. So thank you all. It's been a great experience. And
Madam Chair,
what's that? Yes?
I just wanted to make a quick announcement, but first I want to shout out to my assistant, Christopher Hall. I think that he's really grown into this job and has been instrumental in helping work with OGC and drafting rules and things like that. But I'm impressed with him so much so that he's going to be my assistant general counsel at the Office of State Auditor. So I wanted to announce that before all of you. So I'm taking him with me.
Yeah, we know that. We know you're stealing.
Thank you.
Now the chinks in the wall are coming out. No, I'm kidding. I'm kidding. Just kidding. Well, all I can say is happy trails to you too. The state auditor's office is an honorable place to work. I hope you can make it as wonderful as things have been here. Who knows? And I think the DFA is going to be a much happier place with, not that I don't know whether it's unhappy, but I'm sure it'll be happier than whatever it is with our chief of staff there in charge. So with that, guys, since it's almost 1:37, I think we should adjourn because we're probably all starving. So thank you so much. It's been a wonderful experience.
See you guys.
Take care.